Husband is present.
Okay.
Husband.
And 1 minute.
Husband is sorry.
Nonande.
Opposite party number 2 is
Yes. Informant is present, man.
Abhilipsa Mahapatra. Huh? She is appearing. Who is the lawyer?
I am her.
Okay.
Okay.
And who all are the accused in the FIR? How many of them?
Here, one of the accused, my lord. So far, other in-laws, they have already quashed, my lord. Against this, he is the sister.
Already quashed by?
By this Hon'Ble court.
Another bench, my lord. Coordinator bench.
Very.
Since, my lord, the
Okay. Okay.
this accused, my lord, is the brother-in-law of the informant.
Okay.
For that reason, my lord. 498, 323.
Okay. What is this term of settlement?
Okay.
That is already, I have enclosed the satellite copy of the order of the trial.
Okay. Right now. The petitioner has invoked the jurisdiction of this court under 482 CRPC for quashing of the FIR number so and so under so and so so and so. Petitioner is the brother-in-law. Petitioner is the brother-in-law of opposite party number 2. Both the petitioner and opposite party number 2 are present in the court. They are being identified by the respective counsel. They have also filed their Aadhaar card, photocopy of their Aadhaar card to establish their identity. So, the counsel for the petitioner submits that in the said FIR, there were other accused persons. There were other accused persons, namely Tarakant Mishra and Srimati Basanti Mishra. Basanti? Tarakant Mishra. Kali Tarakant Mishra, namely
Two applicants.
other accused persons also those who are the family members up to the petitioner. Those accused have filed separate petition, namely criminal MC number 950 and 958 of 2023. The coordinate bench of this court, while order dated 26/6/2023, has been pleased to quash the FIR. The relevant is para 427. Para 427 of this, which reads as that. Next paragraph. The petitioner and the respondent have joined petition. The opposite party number have now filed an affidavit dated 10/1/2024, reiterating her stand qua this petitioner as well. Next paragraph. Taking into consideration all the attending facts and circumstances of the case, I am of the considered view that this is a fit case where the jurisdiction under section 482 CRPC should be invoked and full stop accordingly. The FIR number so and so stands quashed. Petitioner now. Next.
Item 2.
Against this petitioner, my lord, 375 million not made out to yours.
And then
Offense been mentioned or quashed?
for the state who tar upare quashing upare. Mr. Garuda, APS for the state and submits that there is no legal impediment for quashing of the FIR as the parties have settled and this dispute is arising out of a marital discord. Take it.
Item 2.
Item, may I please, your lordship?
Plus there is whom
375 million thalan mo ita ko. Cooperative.
the
Here, my lord, the
family dispute why and
here also family dispute, amicable already been settled, my lord, that flag A, the joint affidavit, we have already filed.
what is the offense?
Offense, my lord, the page 12 of my brief, my lord, that 452 to 294,
Where is the FIR?
plus the page 12 of the.
Charge sheet, huh?
Yes,
Charge sheet you filed. What is the offense? You are who all are they?
my lord, the only.
This is
husband-
Jyoti Prakash Mohanty.
Yes, my lord, the son-in-law of the present informant. With the matrimonial dispute, my lord, the both parties are present also before the court.
No, no, son-in-law of
Son-in-law of the
Informant.
present informant.
Gitanjali Chaudhary is the wife.
Yes, no, my lord, see the mother-in-law.
Mother-in-law.
Mother-in-law. And all the cases, my lord, but 498 case and other cases have already been disposed.
Where
of
is the husband? Where is the wife?
Yeah.
The, wife is not the informant.
Mother-in-law is the informant, my lord.
Mother-in-law.
Mother-in-law lodge information against the son-in-law.
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 Yes.
What is the offense?
Plus the 452, 294, 324.
Where is that? Where is that?
7,
Where is that?
506, 507, 34 IPC. And mutual divorce has already been filed, my lord. In the meanwhile, plus the half. of the-
307 also.
Yes, my lord, the half of the amount, 50% of. the amount
About
paid-
money, I am talking about 307. What is the allegation?
Allegations, my lord, the son-in-law came to the house and my lord, the attack with the family members, that is the allegations.
What are the weapon of offense used?
When my lord, the seizure,
Okay.
seizure, my lord, the Conchita use. of that, that is the allegation.
Now they are staying together.
Yes, my lord.
Huh?
My lord, now they are want to settle the issue.
They want to settle or settle?
Settle, my lord, yes, already joint affidavit filed, my lord.
Now, what is the terms of settlement?
My lord, the lordship may kindly see, my lord, the joint affidavit I filed,
Hmm.
with the lordship for a moment, my lord, mutual divorce has already been filed, lordship may kindly page 27.
Hmm.
And relevant page is page 31. In this application, my lord, it was been reflected the.
17 lakh 50,000 they will
already
pay.
paid, and rest remaining.
Already paid. Mutual divorce granted.
No, my lords, the mutual divorce is pending, the half or rest of the amount, 17 lakhs 50,000 will be paid on the day of evidence. So except these case, all the cases has already been withdrawn.
To get the mutual divorce and come because 307.
Lakshmi may kindly for a moment. my lord.
Medical.
Because page 31, Lakshmi may kindly for a moment, page 31.
30.
The page 31 of the divorce petition, my lord. They want, my lord, against each other.
That's right,
cases.
because the manner in which he has attacked the in-laws, tomorrow he will wriggle out of it. Because of the criminal case only, their settlement is taking place.
No,
Once it is
all the
quashed,
cases, my lord,
once it is quashed, then 13B also will not cooperate and
No, no.
everything will be
no,
again
no,
come
no,
to,
Therefore, they.
when,
want-
when 13B petition is pending,
Yes, my lord, the honorable Lanet Judge Family Court Cuttack.
when?
Plus the,
When have we moved this application?
that is, my lord, it will be fixed to, my lord, next week, my lord.
Next week,
My lord.
first motion or second motion?
No, my lord, it has been urgent time and again, because all the cases we want.
Why it is urgent time?
Because, my lord, both the parties wants, my lord, all the cases for settle, my lord, then we'll file the affidavit, then we'll do the mutual divorce. That is out of all the cases, my lord, lordship page 31.
Show me the injury report, show me the injury report.
Lordship, for a moment, all the cases, my lord, have already been withdrawn. my lord.
That's right, but it is a 307 case, I have to just see the injury
So
report.
Lordship indicate, my lord, if not settled, my lord, if the mutual divorce has not been settled, then.
What do you, Mr. Ragada, what do you say?
My lord, they have not given the injury report, my lord. And I look,
Lordship-
But the weapon, it seems to be a seizure, small seizure.
Lordship,
Attacked whom? Mother-in-law, father-in-law?
mother-in-law.
mother-in-law taken up money.
My lord, mine here, my lord, if not settled, Lordship may indicate, if not settled, my lord, then it will automatically revoke. The order is automatically.
Write
That's
down,
my lordship.
write down. The petitioner,
ଆଉ ଗୋଟେ କେସ୍ ତାଙ୍କର ସେଟଲ୍ ହେଇଛି ସେଟା ପେଜ୍ 40 କ୍ରିମିନାଲ ଡିଭିଜନ କରିଥିଲେ ଡିଭି ଆକ୍ଟଟା ସେଟା
We accept this honorable court.
settled ହେଇଯାଇଛି.
ଏ ଅଛି ପେଜ୍ 40
Joint affidavit, so-
Petitioner, who is the, no, the opposite party number 2 has filed, has registered this, the FIR number so-and-so, registered FIR number so-and-so, under section so-and-so, against her son-in-law,
Yes.
who is the petitioner in this case. Next paragraph. The dispute appears to have arisen due to the marital discord between the petitioner and his wife, namely
Pragyan Mahan.
Pragyan Mahan. There are only cross cases or only
Cross cases.
apart from the present FIR, there are cases initiated by the wife of the petitioner against the petitioner under DV Act.
490 case.
DV Act. Next paragraph. The parties have now settle the dispute. Settle the dispute. And agreed and have agreed to part away. Part away. The petitioner has agreed to pay permanent alimony to the tune of 17,50,000 rupees.
35 lakhs out of 35 already 17.
Whatever. 35 total कितना देना है?
Total मतलब 30.
35 lakhs. So 35 lakhs. Full stop. The opposite party number 2, the mother-in-law of the petitioner had filed this. Where is that joint affidavit?
Yes, sir.
Filed this affidavit conjointly with the petitioner and inter alia narrating the terms of the settlement. On the see the full stop. The settlement has full stop. The settlement has already acted upon. A DV case has been accordingly. The DV case has been dropped. Quashed or dropped?
This challenge the order before this honorable court. This honorable was the order.
The DV case initiated by the wife of the petitioner has been quashed by this court. Wide order dated so and so passed by the court.
6/12/2023.
6/12/2023.
6/12/2023.
Passed in criminal revision number 620 of 2023.
Criminal division of 6/12/2020.
And
So
490.
the the parties have agreed that after quashment of all the pending cases, they would apply for the mutual divorce under 13B of Hindu Marriage Act. Accordingly, though the petitioner under 13B has been moved, but it has not been taken up, awaiting the outcome of the present proceeding. Next paragraph. Mr. Ragada appears for the state and states that the dispute is arising out of a marital discord. Although offences under section 307 IPC has been invoked in this case, but the offence of weapon being a seizure, and the offence is only a seizure and procedure. The victim, opposite party number 2, is the mother-in-law of the petitioner, is present in the court and is identified by his counsel, and she has also filed her Aadhaar card to establish her identity. Right. The accused, accused petitioner is also present before this court, and he is identified by the counsel for the petitioner. He has filed the Aadhaar card, photocopy of Aadhaar card before this court. Take the photocopy of Aadhaar card. And next paragraph. Since the dispute is arising out, this dispute is because of the dispute is primarily this dispute being primarily a marital dispute, matrimonial dispute. There is and the parties have settled their grievances. There is no legal impediment to quash the proceeding arising out of FIR number so and so. Full stop. Accordingly, the petition is allowed, and FIR number so and so stand quashed.
I have also filed the Baklatrama for the OP2.
That is the so and so. I filed Baklatrama, which is taken under. Next 3 adjourned. 3 somebody has asked for adjournment, give it in favor. Adjournment जो मांगता है आगे दे दो.
Item 4.
Will not be. Yes. Huh?
On behalf of Mr. Tara Prasad Mahapatra, say kindly take it up next week. Lordship.
Next week may not be possible, we'll see and give the date. Give
Yes,
any
sir.
favor. Yes,
Item
and
five,
see, those who are taking adjournment, keep it note, no memos are entertained. Note down this thing. Memos, memo nahi hai, no preponement. Matters are listed, they have to come. If they don't come, ask for adjournment, it goes to April, February. Don't entertain the memo. Yes.
It is for already disposal of the vigilance case matter pending.
This is item 5?
Yes, madam, item 5.
Yes.
The already disposal of the vigilance case matter pending the vigilance of Hon'Ble matter. The case of 2010 matter. 2009, sorry, 2010.
10.
And till now it has not. been
Yes,
disposed.
vigilance case, huh?
It's
very-
just stand here.
What is the stage of the trial?
At the end of the trial matter.
Hmm?
4 3 witnesses and 4 witnesses are present.
Already it's
Yet
going
to be
on.
examined.
How many witnesses are
It
there?
is in the list of trial matter. It is during the course of trial.
That's right. How many witnesses are there?
4.
Huh?
No, number of witnesses are there, madam. 4 witnesses are left to be examined.
Then
Take it.
at this stage, why should, it's
Yes.
going on,
I have, yes, madam.
it's going on.
I permit to veto, madam. It was
Yes.
filed- it was filed from-
Then counsel for the,
from the back, madam.
by way of this petition, petitioner is seeking indulgence of the court, for expeditious disposal of the trial in vigilance case bearing number CTR 30 of 2010. Full stop. Land counsel for the petitioner states that the prosecution evidence is at the advanced stage. So therefore, he may be permitted to withdraw this petition. The petition is dismissed as with. Next.
item 6,
Passing of criminal.
Yes,
Interesting feature, if I should kindly see page 25.
20,
Page 25,
yes,
the divorce has been decreed on contest.
Bapi Sahu and Priyanka Behra,
Right.
yes,
Divorce is decreed on contest
yes,
on 21st of March 2022. Lordship got the date, my lord, at the bottom of this.
yes, I saw it.
The Lordship see the FIR date, 5th of August 2020.
This is on March,
Right, my lord.
March,
Marriage was not,
after the
after
declaration
the
of.
annulment of the marriage.
And what is the position in the appeal?
I don't think we have no instruction about appeal. They have not filed any appeal. I'll
If
take
the
it.
appeal is filed within time, section 15 steps in.
Yes, yes,
If
remarriage.
the sections 50 steps in, then I believe this FIR can be maintained. Just check it up.
Achha, appeal has not been filed. My instruction is this. My learned friend says that no appeal is filed.
Within time.
No, appeal has never been filed,
Hmm.
but they have filed an application to set aside the decree in the same court. So 15 will not come.
15 will not. How can this FIR be maintainable? Already
And that too,
the relationship is severed by a decree. No appeal under, no appeal filed, so 15 will not come in the play. So therefore, 498, how can you maintain? Oh, but the other offenses, 323,
they're all connected.
but
Connected to
307 can't be connected.
Interesting, Lordship may kindly see. Interesting, kindly see. My lord.
Only you can talk about 498A only.
My lord, others also. Kindly see on the alleged offense is 26/6/2019. That too, kindly read the FIR. There is no whisper about the in-laws about all these offences. And completely it's an afterthought.
Anyway, we will issue notice.
Notice, my lord.
We will notice. Investigation is on now.
Yes,
There
yes.
can't be any stay.
Yes,
It
yes.
is.
No,
Issue notice to the opposite party number 2.
they are also on bail. My lord. They are also on bail.
They
They are also on bail.
opposite party, no, state will notice, huh?
Only a date be fixed, my lord, so that
Date,
they get respite.
See, by the time the matter will be taken up in February, first week or second
That
week.
your lordship may kindly indicate.
Indicated date is second week. Huh? Second week, no, make it eighth. Eighth,
8th of February will do, man.
eighth.
That will do.
By the time investigation also will.
I'll after this.
You will also update your lordship about that setting aside application and other.
Yes, by that
You
time.
can get instruction. in
And it may so happen that the FIR will end up in a final report also.
Maybe. Maybe.
Because there is nothing, I could see it.
Absolutely correct.
Uh,
Great.
Just check it up
My lord, I will confirm.
and try expedite it. See, these kind of cases
Malad.
has to be accurate. These are appears to be a false case,
Malad.
afterthought. So
After
investigation koriକି final report ଯାହା file କରିବେ କରିଦିଅନ୍ତୁ ତାପରେ ଆଗକୁ ଦେଖିବା ଯାହା.
I will take.
Grateful.
Yes.
May I please, your lords? The present petitioner challenging the criminal proceeding, my lord. Initially, FIR was lodged under section 417, 490, 535, thereafter, 417, 494.
What is added?
My lord,
What is added?
my lord, 376 and 32B of SC and STP Act.
Hmm.
The petitioner and the opposite party both are and
At the time of offense,
yes, my lord. 20 years. They means 20 years. And the
no
petitioner-
POXO, no POXO then.
No POXO, my lord.
But 376 is there.
376 in the charge sheet added, my lord. But as per the FIR allegation, my lord, 376 will not made out, my lord. As per the judgment of the Honorable Apex Court in Pramod Suryavan case.
What judgment will do? See the facts first.
In similar fact and circumstance, my lord. the-
Similar.
Yes,
You
ma'am.
have to, in a criminal case, you would see the facts.
my lord,
What judgment will do?
FIR is under Annexure 1, my lord.
Yes, you come to page 22. Charge sheet. Why 376 is added? During the course of investigation,
My
reading
lord. 376 and
Yes.
section 3 of POXO, the SC/ST Act, my lord.
20,
My lord,
page 22,
page 22.
para 3, read it. Why these offenses are added?
May I read to you?
Yes.
During course of investigation, it came to light that the complainant, Jamie Naik, alias Ramuna Naik, aged about 20 years, is the daughter of Lakshmipur Naik, village section of district. While she was attending class of computer course at Raigada, at that time one, Jyotsna Rani Halwa, daughter of such and such, was also staying at Raigada. In prosecuting her study in degree college at Raigada, both her came in contact with each other. Gradually, friendship was built between them during their stay on one Golek Mohammed, the present petitioner. Raigada, for appearing constable interview, came into contact with the Jimmy Naik through Jyotsna Naik Halwa, Jimmy Naik alias Golek Naik Mohammed became closer to each other. Subsequently, they fell in love with each other. Now, Jimmy Naik alias Ramuna Naik prosecuting her studies in +3 first year at SKCG College Paralakhandi and remaining at her Gunpur in rented house. Golek Mahanandia approached Jimmy Naik as for keeping sexual relationship with him with a promise to marry her. Gradually, they engaged keeping physical relationship since last 5 months, and Golek Mahabod used to give some medicine to avoid pregnancy. So Jimmy Naik approached
Who is Jimmy?
the informant,
Informant.
opposite party. But he denied for proposal citing caste problem, for which
The
discussion.
only thing is you had relationship. You promised her to marry and
Yes, ma'am. That is why the
had
honorable,
sexual.
that is why the honorable Apex Court says that my lord 376 will not made out. Neither 376 nor 493.
And SCST is also
Yes, my lord.
there.
Yes, my lord. Taking into
But
yeah, that aspect
where is the
also-
allegation of SCST? From the discussion arose between them and Jamie Naik, asked Golok
My lord.
as to why he kept a relationship with her when he has not the intention to marry her, and he had to know about the caste problem at the time of loving and keeping the relationship. Yes, Mr. Raghuda.
My lord. The case there not with me, my lord. Only the his petition was, my lord. Notice may be issued, my lord.
Anyway, notice has to be,
My lord.
notice,
Hmm.
opposite party number 2.
Now, my lord, NBW issued, my lord. Till then, no coercive action
NVW,
issued, my lord, after filing the charge sheet. my lord.
Not when bail.
where is the application?
No, my lord, I have not annexed that.
You have not got the bail.
No.
Not regarding bail.
No, my lord.
You have not got bail. Go and get bail.
My lord, till then, my lord, no coercive action. sir.
No coercive.
The lordship may call for the case diary.
Case there.
Case diary will come, but you avail the bail. NBW will be issued, obviously.
No, my lord.
After commission certificate and-
has issued the process.
My lord.
Cognizance
You have
taken
not
and-
appeared.
No, my lord. Someone
Cognizance
has
taken
not
and
issued.
inventory issued.
Huh?
Someone
Cognizance
not
has
taken and-
taken, process has been issued, you have not gone, NBW issued. That's what the case is.
No, my lord, cognizance not yet been taken as per my instruction. My lord.
Charge sheet, the moment charge sheet submitted, cognizance must have
Charge
been
sheet,
taken.
just see, you are
Did they-
abstaining.
The date,
Yes, my lord, absconded.
abscond, the moment charge sheet submitted, the
They will issue.
NBW issued on the first instance, my lord, since
NPW
there is not an
till
bail.
that no course of action.
Write down. Issue notice to the opposite party number 2. No, the petitioner is seeking quashing of the FIR. FIR registered by opposite party number 2 under section so and so, FIR number so, section so and so. Full stop. Mr. Mishra, Land Counsel for the petitioner submits that even if the allegation made in the FIR and the charge sheet is taken at its face value, no case under 376(1) is made out in view of the judgment.
Pramod Suryavan.
Huh?
Pramod Suryavan
In
power.
view of judgment of the Honorable Supreme Court reported in, I don't know, what is that, reported in so and so, release the so and so, so and so. Comma, wherein the Honorable Supreme Court has conclusively held that contacting physical relationship with a major with a promise to get married will not attract the offense under section 376. 370. Thanks for full stop. The charge sheet indicates the petitioner has been absconding. Full stop. Absconding. The petitioner, the counsel for the petitioner submits that NBW has been issued against the petitioner. Full stop. The petitioner has moved an application being IA number 2494 of 2023, seeking interim direction. Full stop. Since the petitioner has not availed the remedy of not avail any ventilating his plea for grant of bail in this petition could be granted. However, liberty is granted to the petitioner to surrender before
Sorry,
the
my lord. Yeah,
court
as
if
per-
process has been issued and avail the remedy of seeking bail.
Sorry, my lord, I have not filed any bail application, but there's some.
That's
bail
what I
application.
said. You do
Whether it has
whatever.
been filed or not, I don't have that.
I have
information.
made some observation which will help you go and do it. The idea of making observation is this, otherwise issue notice, I should not have written all these things. Idea is writing is at least you will get the bail.
Okay.
Take the order and annex it and get the bail.
Urgent to-
No, not disposed of, notice.
Oh,
We have only notice.
Urgent.
IA is disposed of, main matter notice to be retainable in February, give it on 28th or 29th. Meanwhile, go and get bail.
Obligation.
Item 8. Pass over. Okay.
My pleasure. Lords.
Yeah.
Milord, this 482 application has been filed, Milord, to quash the proceeding, Milord, on the account of compromise, Milord. It's a dispute between the husband and wife. Milord, wife lodged an FIR, Milord, under section 498, 341, 290.
Settle.
It has been settled and both of them residing, Milord. Together.
Where are they?
No, Milord, for the first time, Milord, it has come, Milord, notice is to be required, Milord. No, same thing, all collusive here, so that is why, Milord, earlier also, your Lordship has, this honorable court, notice.
Petitioner has invoked the jurisdiction of this court seeking quashing of the FIR number so and so, comma, which is arising out of a matrimonial discord. And counsel for the petitioner submits that the parties have now settled the dispute and they started residing
Together.
Therefore, he submits that in the interest of justice and to save the matrimonial life of the petitioner and opposite party number 2, the FIR in subject may be quashed. Issue notice to the opposite party number 2.
Logically fix a date also, both of them will present.
Opposite party number 2 and the opposite party number 2 returnable by 1 week. The petitioner and the opposite party number 2 may present in the court to reiterate make a statement regarding the settlement. You give it on 17th. ये मेट्रो छोटे मेट्रो थोड़ी खत्म
Millet, GR case number, Millet pending in the court, Millet maybe statement.
Write down, I don't know, whatever you written, we will take.
Millet, I have filed, Millet, because the case is posted to 12th, Millet.
अच्छा, stay you want.
Millet.
IA number of 2501 of 2023. In view of the submission made at the bar by the Learned Counsel of petitioner, the IA is allowed. The proceeding pending before court of so and so. I represent is stay till further proceeding, till further orders. Okay. Yes. Then, yes.
May I please, your Lordship? Lordship, petitioners, there are two petitioners in this case, Lordship. They have
Two
challenged the-
petitions.
Two petitioners, Lordship. They have
10,
challenged.
na? Only one petition. Two petitioners.
Right, Lordship. The two petitioners, they have challenged the order of cognizance, Lordship. Cognizance taken under section, Lordship, 379, 411, 419, 465, 468, 471, 34, and 120B, Lordship. The petitioners, Lordship, they are working as a junior engineer in IOCL, Paradip, Lordship. And Learned Court has taken cognizance, Lordship, against them without taking any sanction, Lordship, in this case.
Sanction.
Lordship.
Or they will, they'll get the benefit in the trial. For
They are the central government employee, Lordship. and-
what is the allegation? Whether it is
Allegation-
coming under the color of duty or not?
Yes, Lordship.
Why? What is the allegation?
Allegation, Lordship, what happened, Lordship, in this case, Lordship? One person, he has entered in that premises of IOCL with a vehicle, Lordship, with 8 number of containers, Lordship. And when he entered that premises, Lordship, IOCL premises, he has shown an identity card and the pass. In identity card, he has shown one of the sitting employee of that company who is the petitioner number 1. And his identity card, he has showed as a duplicate identity card he has made that outsider, and he subsequently entered in that premises. And subsequently, what happened, Lordship, subsequently, when the security staffs asked, and they have checked the veracity, and they found that this is a forged one. That person has made identical to the original ID card, and subsequently they came to know that that person was connivance with these petitioners and other staffs, Lordship. And they are taking regular basis, they are taking the thing, Lordship, that alkalite from that premises, and that's holding it to outside, Lordship. And they have personating this petitioner. He has not named in the, though he has not named in the FIR, the petitioner 1 and 2, but they are not at all related in this case, Lordship. Some outsider making forged ID card and utilizing it as genuine. And based on that,
Is this allegation what the
Charge sheet has already submitted.
No,
Cognizance taken.
no, that type part, whether it is coming under the color of duty.
yes, Lordship,
So how,
they are in,
how
Lordship, both the petitioners, they were on the duty, and Lordship, and
it might have, the offense might have taken place in the office, but this offense, the allegation doesn't come under the color of duty. So therefore, it is again open to them whether they will take sanction or not. And you, if it is really sanction is required, then you will get benefit at a
Lordship,
appropriate
At the
time.
time of,
Lordship, may I submit one thing, Lordship?
But what you have narrated,
Lordship,
on that basis, according to me, sanction may not be required.
Lordship, the allegations, what are the allegations labeled against the present petitioners and those
You
activities?
are the engineers,
we are the engineers. Lordship.
engineers, yes.
Lordship. And that activities you are carried out inside that premises when I was,
Maybe offense might have, suppose a murder takes place in the office, then
Lordship.
sanction is required.
No, Lordship,
Then-
that heinous crime and the crime, there are certain crimes, offense which sanction is not required, Lordship. In, as per the one.
See, in the place of, if a workplace, if some offense is taken place,
Lordship,
doesn't mean that it is coming under the color of duty. If it is the qualifying requirement for sanction under 197 or the section 19 of PC Act is,
Lordship,
it's the allegation should come under the color of the duty
Lordship,
during the course of your duty.
Lordship,
Then only sanction is required.
Lordship,
This is not coming under, you are engineers.
Lordship. We are engineers, certainly, Lordship, and the allegations are coming when we are on the duty, Lordship.
Maybe you are maybe duty.
And that allegations presume that, Lordship, when
Maybe
we are in the duty.
That's
we
what
are-
I'm saying. In the place of, in the workplace, if something happened, doesn't mean that sanction is required.
See, clear cut 197, Lordship, saying is the
No.
one. Lordship, the sanction.
ଯଦି ଡ୍ୟୁ ଡିସଚାର୍ଜ ଅଫ୍ ଡ୍ୟୁଟିରେ ହେଇଥାନ୍ତା ତେବେ 197
Yes,
ରେକର୍ଡ
Lordship, we
they are not ଡ୍ୟୁ ଡିସଚାର୍ଜ ଅଫ୍ ଡ୍ୟୁଟି
During the course
at
of
time of
duty,
occurrence.
course of the your assigned duty, if something happens, then it
Lordship,
happens.
we are,
Doesn't come.
Lordship, the responsibility we are taking up, that is coming
What is
under,
your responsibility as
La-
engineer?
Lordship, our responsibility is
Hmm.
to carry out, to check that part on ship, where the, we are in the MS bleeding side, that bleeding side, that illegal activities which was taking away from that
Then
place.
you argue all these points at this stage of framing of charge. Write down. The petitioner, by way of the present petition, has challenged the order dated 21/7/2023, passed by JMFC Ersema in GR case number 268 of 2023, whereby the learned trial court has taken cognizance of the offence under section so and so against the petitioner. The charge sheet was filed on, when the charge sheet was filed? Yeah,
Charge sheet filed on.
it is
4th
very
July.
surprising that you are challenging the cognizance order, charge sheet is not filed.
Charge sheet filed,
Not
Lordship.
filed.
Where is that charge sheet? Where
Charge
is
sheet
that?
not
Show me.
Charge sheet not given. Lordship.
Where is the charge sheet?
Only cognizance order. FIR
You file a cognizance order, you think that everything will be passed. These are the minimum thing.
Lordship.
Cognizance is taken on what? FIR.
Based on the charge sheet, Lordship.
Where is the charge sheet then?
My apologies.
The court is not entitled to, on that ground itself, I should dismiss. Henceforth, I'll dismiss it. If cognizance order is passed, at least the charge sheet should be there. It is your petition, you have to substantiate your case. Without filing charge sheet, you want the cognizance order should be passed. One half a page cognizance order, it has to be passed. When the charge sheet was filed?
Lordship, 4th July 2013.
First line of the cognizance order.
4th July 2023. So, 23, and the cognizance has been taken by the court below on 21/7/2023, which is under challenge. Also, the sole ground of challenge by the challenge is that the prosecution has not obtained sanction before, not obtained sanction and placed on record, and the trial court has erred by taking cognizance without there being appropriate sanction. Do you need, I should observe, or I'll keep it open?
Lordship, may kindly.
It will prejudice you. Why don't you understand? Sir, I am of the considered view. I am of the considered view that the present petition is the petitioner. Cut down. The petitioner seeks to withdraw the petition at this stage to raise all his objections at appropriate stage of the trial. Next program. The petition is disposed of disposed of, reserving the right to the petitioner to raise all his um, contentions and contentions before the court below at appropriate stage. Stands disposed. But henceforth you file cognizance order, you must file the charge. Okay? But these are minimum thing. You are a young guy, why should you do that? Yes.
Item 11.
Yes.
My lord, as far as this petition is concerned, he has filed the squashing of section 6, this
SC,
section
ST.
3 SC/ST Act.
SC,
Excellent.
yes.
And as far as coming down straight to the facts of the case,
Yes.
the petitioner is a doctor and the informant is also a doctor, both of them working in.
Charge sheet has been filed.
Investigation has
In
preliminary stage.
investigating stage, you want quashment.
Exactly.
Nothing happens.
My lord, as far as this.
Will you wait? Will you wait?
Wait for?
Wait for the charge sheet to come.
That point.
At this stage, no question of question.
Why I am submitting is.
Maybe your why may be,
Because,
why may be correct, but still, see, we can't
I'm.
curtail the investigation.
My lord, I am not on that side.
Yes.
The thing is that, me, and the father of the petitioner and the father of the informant, we all are friends, and they are going for a mutual.
Then
consider-
what?
That is the, we want to.
Okay, I understand your
We
personal
want to
problem.
notice only, thereby.
Then what I'll do is, I'll simply adjourn it. I'll simply adjourn it, awaiting the charge sheet. I'll not say anything. Because you will be in an embarrassing situation. Huh? I'll simply adjourn it to first week of March. Let us see, by that time, charge sheet may be filed. Then you amend it, then we'll look into it.
That's the point. That was the
I will not say anything. Simply adjourn to March, first week.
obliged.
By that time, I believe they will file.
No, it is on the process. It is on the, it is
No,
already.
if it is filed earlier, you can very well mention. You can mention it, you will be reported.
Case cross case.
Let's say he personally somehow doesn't look nice for. I understand the difficulty of a lawyer. Anyway, we'll do that. Okay.
12.
Yes.
Well, I am for the petition of paying the person of criminal proceeding in view of the compromise between the parties, my lord.
What is the offense?
So the offense, earlier offense are under.
307. Medical.
395, 397, and 24, 25
Oh.
are answered. But charge sheet has been filed.
Show me the injury, show me the,
397.
show me the injury report.
My lord, injury reports as per Annex 2.
Annexure?
2. Page 17.
Yes.
Injury. has
Mr. Agada,
been-
just,
I am for the informant.
what do you say? You have settled.
Joint affidavit.
But there is 307. Let us see.
Joint affidavit.
Maybe. Mr. Agada, just see. Who is appearing? Just see.
395
394.
in this case, let's make it see.
Yes.
395, 397. Brutally assaulted.
Charge sheet has been filed with 394. Page 90.
Very charge sheet.
Page 397 and 4.
Hey, what are the offenses in charge sheet? Where is the charge sheet? Copy of charge sheet?
Page 19, head and order dated 14/9/2020.
This is 19.
49, 2000,
14/9/2020.
22.
No,
No, this is certified copy of order dated 14/9/2022. What is this?
The case record is photocopy as there on Madras and.
Now, where is the charge sheet?
Charge sheet क्या है ना?
That's
Where is that? It's not there on record. Compromise and everything you filed except charge sheet.
Absconder, case of 2019 NBWC.
Today, my lord. Petition of court.
Maybe, but see, the offenses are serious. I have to see the charge sheet.
Not a certified copy of the order.
Order maybe, that is a different thing, but where is the charge sheet? The prosecutor has also to see that 394 is there, 397, 307.
No,
And,
307 is.
327 is not there.
No, 394, 397 IPC. On perusal of the material available on the record,
What is the allegation? Let us see.
my lord.
They are both doing business, they are doing business, my lord. The business friends, my lord. Both are doing business.
There-
They are business friends.
What is the allegation?
Dispute between the, regarding the business, my lord. Both friends quarreled each other, then misunderstanding there.
That's right, but what is the allegation I am asking?
Allegation is-
Nature of allegation.
My lord, allegation said that,
Please read it.
So far as the FIR.
What what is it?
12, my lord. ନିର୍ବାହ କର 22/10/2019 ତାରିଖ ରାତ୍ର 10:45 କେତେ ଜଣ ଦୁର୍ବୃତ୍ତ ହଠାତ୍ ଆସି ଦାଦାବଟି ମାଗିଲେ ଏବଂ 20,000 ଟଙ୍କା ଦିଅ ମୋ ଭାଇକୁ କାକୁତି ମାନେ ଧୋଇ ନ କହିଲେ ମୁଁ କେଉଁଠୁ ଟଙ୍କା ନେବି ଆଣିବି କହନ୍ତେ ଆସାମୀ ମିଟୁ ଦାସ କାଳନ୍ଦୀ ଦାସ ତା ଘର ସହଯୋଗୀ 3 ଜଣ ମାନେ ହାତରେ ଧରି ରଡରେ ବାଡେଇଲେ ମୋ ଭାଇର ମୁଣ୍ଡ ପଛପଟରେ ମାଡ଼ ଦେଇ ଫାଟି 12 ଗୋଟି ଷ୍ଟିଚ୍ ହୋଇଛି।
ଆପଣ copy of charge sheet file କରନ୍ତୁ. I'll take it up on 17. I just want to see that. If the charge sheet is only this much, then we will pass it. Okay. File is as well.
Both parties are
161 statement also annexed, my lord.
Where is that?
Page 14 and 15. Page 14 is informant,
Yes.
page 15 is injured man.
This is the informant, Manoj Vishwal. Read it. Mona Manoj Vishwal.
ମୁଁ ଆଜି ଏତିକି ଆପଣ ନିକଟରେ ମୋର ଦେବା ବୟାନ କି ରାତିର 9:15 ଘଟିକାରେ ମୋର ଭାଇ ସରୋଜ କୁମାର ବିଶ୍ୱାଳକୁ 2 ଜଣ ବ୍ୟକ୍ତି ଶରତ ଦାସ ଏବଂ ତାର ସହଯୋଗୀ କାଳିଆ ଦିନ ସାର ମରାଠମୁକ୍ତ କେନ୍ଦ୍ରାପଡ଼ା ମେଡିକାଲରେ ଚିକିତ୍ସିତ ହେଉଥିବା ସମୟରେ ମୁଁ ତାଙ୍କୁ ପଚାରି ବୁଝିବାରୁ ସେ ଥଙ୍ଗା କହୁଥିବାରୁ ମୁଁ ସ୍ପଷ୍ଟ ଭାବରେ ସେମାନେ ତାଙ୍କୁ କେତେ ଟଙ୍କା ନେଇଥିଲେ ଏବଂ କେଉଁ ଅସ୍ତ୍ରରେ ମାରିଥିଲେ ତାହା ସ୍ପଷ୍ଟ ଭାବରେ ଶୁଣିପାରିନଥିଲି। ତେଣୁ ମୁଁ ତରତର ଭାବରେ ମୋର ସାଙ୍ଗର ଶରତ ପ୍ରଧାନଙ୍କୁ କହି ଏକ FIR ଲେଖି ଥାନାକୁ ପଠାଇଥିଲି। ମୋ ଭାଇ ସୁସ୍ଥ ହେବା ପରେ ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ ସେମାନେ ତାଙ୍କଠାରୁ 14-15 ହଜାର ଟଙ୍କା ଏବଂ ଏକ ଭିଭୋ ଆଣ୍ଡ୍ରଏଡ୍ ମୋବାଇଲ ଫୋନ୍ ନେଇଛନ୍ତି ଏବଂ ତାକୁ ଏକ କାଠ ବଲ୍ଲାରେ
କାଠ ବଲ୍ଲାରେ।
The next page is the injured statement. The next page is the injured statement. 15,
Next,
page
read it.
15.
Statement of Opuna.
Yes, Apuna alias Saroj Kumar Mishra. He is the injured.
Yes, injured. Read it.
ମୋର ନାମ ଅପୁନା ସରୋଜ ବିଶ୍ୱାଳ। ମୁଁ ବିକାଶ ରଞ୍ଜନ ଖୁଣ୍ଟିଆ ସହ ପାର୍ଟନରସିପରେ ସହକାରିଆରେ ଏକ କବାଡ଼ିଆ ଦୋକାନ କରୁଛି। ମୋ ପାର୍ଟନର ବିକାଶ ଖୁଣ୍ଟିଆ ଆଗରୁ ମାର୍ଶାଘାଇ କେନାଲ ବ୍ରିଜ ନିକଟରେ ଏକ କବାଡ଼ିଆ ଦୋକାନ ଦେଇଥିଲେ। ଏହି ସମୟରେ ପାରାଦୀପର ମିଟୁ ସରୋଜ ଦାସ ପିଟିସନର ଏବଂ ତାଙ୍କ ପାର୍ଟନର ଉଲ୍ଲାସ ଚନ୍ଦ୍ର ସ୍ୱାଇଁଙ୍କ ସହିତ ତାଙ୍କର ପରିଚୟ ହୋଇଥିଲା। ପାରାଦୀପରେ ସେ ଦୁହେଁ ଠିକାଦାର କାମ କରୁଥିଲେ। ସେ ତାଙ୍କଠାରୁ 2 ଲକ୍ଷ ଟଙ୍କା ଧାର ସ୍ୱରୂପ ଆଣିଥିଲେ। ଆସ୍ତେ ଆସ୍ତେ ସେ ତାଙ୍କୁ ଧାର ପଇସା ଫେରାଉଥିଲେ। ମିଟୁ ସରୋଜ ଦାସ ନାମକ ଜଣୈକ ବ୍ୟକ୍ତି ଏଠାକୁ ପଇସା ନେବା ପାଇଁ ଆସନ୍ତି, ଏଣୁ ମୁଁ ତାଙ୍କୁ ଚିହ୍ନିଥିଲି। ତା 22/10/2019 ତାରିଖ 4 ଘଟିକା ସମୟରେ ମିଟୁ ସରୋଜ ଦାସ ଏବଂ ଅନ୍ୟ ଜଣେ ଏକ ସ୍କୁଟି ମୋଟରସାଇକେଲ ଆସି ଆମ ଦୋକାନକୁ ଆସିଲେ। ସେମାନେ ତାଙ୍କଠାରୁ ପଇସା ନେବାକୁ ଆସିଥିଲେ। ସେତେବେଳେ ସେ ଦୋକାନକୁ ଘରକୁ ଯାଇଥିଲେ ଏବଂ ସେମାନେ ତାଙ୍କୁ ଅପେକ୍ଷା କରିଥିଲେ। ଏତଦ୍ ବ୍ୟତୀତ ସରୋଜ ମଧ୍ୟ ତାଙ୍କୁ ଫୋନ୍ କରିଥିଲା। ସେ ତାଙ୍କୁ ଦେଖା କରିବେ ବୋଲି ଫୋନ୍ କରିଥିଲେ ଏବଂ ବହୁତ ସମୟ ଅପେକ୍ଷା କଲା ପରେ ପୁଣି ବାରମ୍ବାର ତାଙ୍କୁ ଫୋନ୍ କରିଥିଲେ। ସେ ନ ଆସିବାରୁ ମୋତେ ବିକାଶ ଖୁଣ୍ଟିଆକୁ ଫୋନ୍ କରିବାକୁ କହିଲେ। ମୁଁ ଫୋନ୍ କରିବାରୁ ସେ ମୋତେ କହିଲେ ଯେ ସେ ତାଙ୍କ ମାଆଙ୍କ ଦେହ ଖରାପ ଥିବାରୁ ମେଡିକାଲ ବ୍ୟସ୍ତ ଅଛନ୍ତି। ଲାଷ୍ଟ ପର୍ସନ
କଣ ପଢୁନାହାନ୍ତି, ତେଣୁ ତାଙ୍କୁ ଖାଇବାକୁ ପିଇବାକୁ ଦେବା ବିଦା କରିଦେଇଥିଲେ। ମିଟୁ ସହିତ ଥିବା ବ୍ୟକ୍ତି ଜଣଙ୍କୁ ମିଟୁ ଦିନ ସାରା ସାର୍ ବୋଲି ଡାକୁଥିଲା। ବିକାଶ ଖୁଣ୍ଟିଆ କହିବା ମୁତାବକ ମୁଁ ତାଙ୍କୁ ଖାଇବାକୁ ଦେଇଥିଲି। ଖାଇସାରିବା ପରେ ମିଟୁ କହିଲା, ଆମେ ଦିନ ସାରା ବସିଲୁଣି, କଣ ଖାଲି ହାତରେ ଫେରିଯିବୁ, ତେଣୁ ତୁ ଆମକୁ ପଇସା ଦେ। ମୁଁ କୋଉଠୁ ପଇସା ଆଣିବି ବୋଲି କହି ମନା କରିବାରୁ ସେ ଦୁହେଁ ମିଶି ମୋତେ ଗାଳିଗୁଲାଜ କରି ସେଠାରେ ପଡ଼ିଥିବା ଏକ କାଠ ବାଲ୍ଲାରେ ମୋତେ ଜୀବନ ମାରିଦେବାକୁ ମୋ ମୁଣ୍ଡ, ପିଠି, ଗୋଡର ମାରାତ୍ମକ ମାଡ଼ ମାରି ରକ୍ତାକ୍ତ କଲେ ଓ ମୋତେ ଘୋଷାଡ଼ି ନେଇ ଦୋକାନ ଭିତରେ ଟଙ୍କା ବାକ୍ସ ଓ ଅନ୍ୟାନ୍ୟ କାଗଜପତ୍ର ଖେଳାଖେଳି କରି ଖୋଜାଖୋଜି କଲେ। ଟଙ୍କା ପଇସା କିଛି ନ ପାଇବାରୁ ମୋତେ ପୁଣି ନିସ୍ତୁକ ମାଡ଼ ମାରିଲେ। ଫଳରେ ମୁଁ ଚେତାଶୂନ୍ୟ ହୋଇ ଯାଇଥିଲି। ସେହି ସମୟରେ ମୋ ପାଖରେ ଥିବା ବ୍ୟବସାୟ ପଇସା 20,000 ଟଙ୍କାରୁ
They were assaulted. He was assaulted and
Yes.
Money was taken.
Yes.
So just see now he has entered into, Saroj Kumar Vishwal has entered into settlement. Who is Saroj Kumar?
Saroj ki सही बात।
And who is that informant?
Informant is
Sorry, who is the accused? Mithuda.
Our two friends and partners.
My business on mission only he. There is a dispute business.
Whatever dispute is there, but the allegations are there, but still, okay. By way of this petition, the petitioner seek indulgence of this court for passing of the cognizance order.
Criminal proceeding.
Cognizance order, you have seen cognizance order.
Wrong.
Ah, see that.
Passing of the criminal prosecution.
Yes.
Initiated against him. Initiated against him in GR case number 1636 of 2029, arising out of Kendrapada Sadar PS case number 298 of 2009, under section so and so. The Learned Trial Court has already taken cognizance of offence on 14/9/2022, which is also essayed before this court. The next paragraph, the allegation, the petitioner being the accused and the informant being the opposite party number 2, or in the 2 and 3,
Yeah.
opposite party. Who is Manoj Vishwal? Why have you implemented him?
Manoj Vishal is the younger brother of the.
He is the informant.
Man.
Yes.
Soroj is the injured.
Yes.
Okay. What have you written? Informant being opposite party number 2, and the injured being opposite party number 3 are present in the court through their respective counsel. Full stop. The learned counsel for the petitioner and the opposite parties have identified their clients in the court and clients in the court. They have also filed their Aadhaar card to establish their identity. The parties to this proceeding have also filed a joint compromise petition at Annexure 7, and have stated that they are the business partners, and to buy peace and to maintain tranquility in the area, they would not proceed with the matter further. The next paragraph. The allegation against the petitioner is that he has where have you read that? Where have you read that? He has attacked the opposite party number 3 by a wooden stick.
Yeah.
Wooden stick.
Wooden stick.
And looted 2,000 rupees. 20,000 rupees and the mobile phone.
Not for 15,000.
Therefore, the present case was registered. After
15,000.
investigation, charge sheet was filed under section.
394. 394 or 397, I think.
394 and 397 IPC. 394/397 IPC against the accused petitioner. Full stop. Next paragraph. Next paragraph. Learned counsel for the state repeats that despite the allegations are serious, but taking into consideration the fact that the parties have settled the dispute, and they being the business partners, jurisdiction of this, the inherent jurisdiction of the court could be invoked, full stop, and there is no legal impediment, Next part, taking into consideration the entirety of facts and circumstances of the case, and the relationship between the accused and the opposite parties, parties, apart from the fact that they have settled their dispute. This court is of considered view that the inherent jurisdiction of this court may be invoked for quashing the quashing the criminal prosecution in subject. So accordingly, the cognizance order dated so and so, passed by so and so is quashed, and the criminal prosecution against the petitioner at the instance of opposite party number 1 and 2 is dropped.
2 and 3.
2 and 3 are dropped. Petition accordingly disposed of. Next.
Item 13.
Yes.
May I please? Here in the petitioners have filed application for quashing of criminal proceeding on the ground of compromise Miller.
Compromise.
Yes.
Who are the
On
what is
last
the offense?
application,
What is the offense?
offense 294, 506, 34 IPC.
Yes.
And under section.
Who are they? You are appearing. What?
And,
who in
joint affidavit has been filed. in there.
joint affidavit?
Yes.
Advocates are appearing, huh?
Yeah.
What is the allegation?
Allegation that while the complainant was working in the field, at that time, the present petitioners had gone to that side. As because the civil dispute was pending between the complainant.
Abusing obscene languages and derogative words, used derogative words against the caste. That's all.
What is this joint affidavit is there? Joint affidavit.
Not
Number
deal.
2, not joint affidavit.
That's it.
But just see joint affidavit. Joint
Yes,
affidavit.
joint affidavit.
Joint affidavit. The petitioner have filed this petition under section so and so, seeking quashing of the criminal proceeding in special GR case number 2 of 2015 of so and so, page number 4 में लेना, prayer में जो लिखा है, ठीक है, so and so. The petitioner has implemented the
I mean, pardon.
informant. Is informant?
Let's see. Kanta,
What is this, Dasarathi? What is this orders you have filed?
Madam.
You are relying upon these orders or what? B. So many things you have filed.
FR is at page 10. FR is at page 10.
Kanta, what he has filed so many things. That's what I'm wondering. IA number, prayer in the IA he has filed. So anyway,
So I stay by file.
stay was granted, huh?
Individual was stayed.
No cost.
Acha. I have. Why the matter was filed joint affidavit and thing therein. Petitioner further submits that in the meantime NBW has been issued against the client. Why the matter was urgent earlier? 5/1/2024.
As Lordship, we request to file joint affidavit, Lordship.
Okay. लिखो. First paragraph हो गया ना? देखो. The matter was earlier. Taken up by this court on 5/1/2024. 24, and the following order was passed. Pursuant to the next paragraph. Pursuant to the said order, the petitioner and the opposite parties have filed a joint affidavit, which is placed on joint affidavit dated 8/1/2024. 24, which is placed on record. So in the joint affidavit, they have reiterated their stand that to buy peace and to maintain cordial relationship amongst themselves, they don't want to proceed with the matter and proceed with the matter. Now, the opposite party number 2, who is the informant, has no objection if the criminal prosecution is dropped. Take next paragraph. Taking into consideration the averment made in the joint affidavit and considering the fact that the allegations against the petitioners are minor allegations, this court is of the considered view to this court is of considered view to exercise the jurisdiction under 482 CRPC. Then comes for the state submits that there is no legal impediment in invoking the jurisdiction of this court under 482 CRPC and quash the proceeding. Accordingly, for next program, accordingly the petition is allowed and the petition is allowed and the criminal proceeding in special GR case जो prayer fila so and so stands quashed, petition is disposed of. We call the
time. Now the matter is pending before the learned additional session judge come judge special court.
Give it. I'll just return within 5 minutes.
Yes, sir.
Item 14.
My pleasure.
Yes.
It's a Belgium matter. It's a Belgium matter. The petitioner was granted bail on 19/7/2020.
19?
19/7/2000. 7/2000.
2000, huh?
Bail was granted to the petitioner.
2000.
2000.
Bail was granted.
And the individual was issued
on
8/10/2009.
And we are 2023. You are coming now.
Well, because the matter was split up against the petitioner and the concerned council did not inform about the matter. And three accused persons, there are altogether four accused persons.
Hmm.
3 persons faced trial and they have been acquitted. Page 9, your lordship, 8/2/2021.
Now, what happened 2009 onwards? Whether you have
Well, he has
declared
gone-
proclaim offender?
Problem, my lord, he is not included, he has gone out of state, my lord, for daily livelihood, that's why that.
No, you have to tell me 2009 if the trial is separated.
My lord, that was not within my knowledge. That was not in
But
my
what
knowledge.
happened, you must be knowing it. Now, proclaim offender has been declared or what?
Order
My lord,
dated
yes.
2/4/2019. Order dated 2/4/2019, page 8.
Yes, well,
Page 8.
notice was issued to the
Page 8.
bailer. On the
82,
instruction of
83
the London
process has
CGM,
already-
on the instruction of the London CGM, the matter was split up and against the petitioner and process was issued against under section 82, 83 CRPC, notice to bailer. That was there.
82. Oh, but you have not challenged that 82, 82
No, ma'am.
proceeding. You have to challenge that
No.
order.
May I pray on your lordship on surrendering, I may go on to continue my previous rule so that the matter.
No question of previous page. You have absconded. What is this? 2009 NBW is issued.
No.
And you did not cooperate because now the other accused persons are acquitted, so therefore you are so keen to.
No,
now.
that's not, I will face the trial. I will face.
You
the-
have to face the trial.
Yes,
You have to face the trial, but you have not even challenged that proclaim offender order.
that I have.
That you have to challenge.
Lordship, may kindly allowed to go on surrendering, I may be released.
No. You have to challenge this order. You have, what is it, which is it? You have now challenged the order dated 2009.
Right.
Subsequently, the order has been passed on 2009, 2019. Which is the order?
Two-
21. Proclaim offender, which is the order? Proclaim offender.
2/4/2019, page 8, last. Proceed with the trial against the other accusation and to issue process under section 82, 83 CRPC. उल्टा क्यों लिखा हूँ? पता है।
What is the offense?
Offense number 457, 380.
457, 380. Offense is very hard.
Lordship, kindly consider.
The petitioner is petitioner has challenged the order dated order dated order dated 8/10/2009 whereby NBW has been issued against him for non-appearance before the trial court during before the non-appearance before the court below in the trial of GR case number 119 bracket A of 2000 under section
457, 380.
457
380 of
and 380 IPC.
457, 380, 411, 34 IPC.
Initial affair was lost for petition
So,
380.
ठीक है, all
411 and
Okay.
434.
The result of the record indicates that after the NBW was issued, the petitioner was proceeded under section 82/83 CRPC. And the trial insofar the other three accused persons.
Yes, three
Other three accused persons were segregated. So, sir,
And they have been acquitted, page 9.
The other three accused persons, those who have faced trial, appears to have been acquitted by the trial court.
On dated 8/2/2021.
By the order dated
8/2/2021.
8/2/2021, passed by
Passed by the London SDGM Banki.
8/2/2021,
8/2/2021.
passed by
London SDGM
Learned
Banki.
SDGM
Banki.
Banki. Full stop. Land counsel for the petitioner submits that he had no knowledge of the order dated 8/10/2009 as his counsel has not informed him. Surprisingly, he has not challenged the order subsequent order dated which is that subsequent order dated
2/4/2019,
by which he has been proceeded under section 82, 83 CRPC. CRPC. Full sir. The petitioner submits that he was on bail by the order dated 19/7/2000. Next, sir. Taking into consideration the facts and circumstances of the case, the order dated 8/10/2009 and subsequent order dated 2/4/2019 are passed by SDJM Banki are quashed subject to the condition that the petitioner would surrender to the jurisdiction of the court and avail fresh bail from the jurisdictional court. The fresh bail jurisdictional court. Okay. On its merit. Let him surrender and
Yes.
get the fresh bail.
Yes.
The earlier bail goes.
Yes, yes.
Okay. But see, if you don't quash,
Again, it will.
same thing.
Yes.
It is better that quash it
Better,
and
yes,
let
yes.
him go and surrender
Better,
and
yes.
let it go to a conclusion. Next.
Item 15.
Dispose of 15.
May I please, Your Lordship? On the last occasion, Your Lordship had heard this matter and Your Lordship was pleased to issue notice to the opposite party number 2. But during hearing of this case, Your Lordship pointed out that in the prayer portion, apart from the quashing of the affair, it has been mentioned as the quashing of all other consequential orders, Your Lordship. And that's why I was directed to file an amendment petition. I have filed that it is as flag B as IA number 60 of 24.
What have you asked?
That amendment petition is filed for amending paragraph number 1, 11 and prayer portion of the main application, wherein it has been inadvertently mentioned as
Charge sheet has been filed.
No,
Your Lordship.
investigation is going on.
Investigation is
Girl
going
has not yet been rescued.
They have already entered marriage, Your Lordship.
But girl is not rescued and have you served opposite party number 2?
My lord, no, Your Lordship was pleased to issue
He is
notice.
15 years.
My lord, both belongs to Muslim as per Mohammedan law.
As your lordship directed me to take instruction, at least since they have married. But the parents, I took instruction from the IAC. The parents of the victim, they were sitting in front of the police station in order to rescue the victim. They are demanding to rescue the girl. This is the situation.
They are the informant.
Yes, they are the informant. And this is the situation in a.
You can't be quashed. You have issued notice where that let the girl come.
Your Lord-
Let the girl come, we'll see.
Your Lordship,
Please.
simply allow my amendment petition, that is IA number 60 of 24.
Issue notice to opposite party number 2, registered post. Have you implemented the
My lord,
opposite party number 2
my lord.
and 1 also? 21, no.
OP number 2 is
Who is the informant?
My lord, OP number 2.
Who is the informant in this case?
My lord, OP number 2. Your Lord.
Sultana Begum. Sultana Begum is the, yeah, no.
No.
The informant is,
No.
the informant is Sultan Begum. Opposite party number 2.
Girl,
Girl is petitioner number 2, Your Lordship.
Petition number 2,
Meher Fatima is the
Meher Fatima,
Is the
15 years.
is the victim girl.
better you file a both joint petition. This is joint petition. It's habeas corpus petition.
Minor तक केम त्या भीतर रखते
The Land Council for the petitioner submits that requisites you have filed.
No, my lord, two more days, Your Lordship, because Your Lordship was pleased to pass order on Friday and Saturday, Sunday, both are holidays.
Okay.
So 2 more days. can be
Land Council for the petitioner has filed an IA number 60 of 2024 seeking amendment to the prayer, amendment to the prayer. The IA is allowed, allowed, and petitioner is given liberty to file amended petition, incorporating the prayer, next paragraph. On 5/1/2024, notice was issued to respondent number 2. However, the petitioner has not filed requisite and taken, however, the petitioner has not taken steps to serve the, not taken step for the purpose of serving opposite party number 2. Let needful be done within a period of 1 week. 1 week, least the matter. First week, second week, 13th February.
Obliged him.
Item 16.
May I please?
Yes.
Miller, here the petitioner challenging the entire criminal proceeding on the ground that matter has amicable settled between the parties. Your lordship, all the offences are triable by magistrate. Well, these are the
Yes, who is the, who is opposite party number 2?
opposite but the informant, my lord.
Where is he?
I am not the informant.
Joint set affidavit?
Yes, I have filed the affidavit.
Where is that?
Your lordship may kindly see.
Just see, FIR is, charge sheet has been filed.
Charge sheet has not been filed.
There are 2 FIRs you have filed.
Counter, there is a case and a counter case. I have given the FIR against the her. They have given FIR.
Which one you want to go?
Milord, annexure 1, milord.
No, annexure 1. What about the other FIR?
Other FIR annexure 2, milord.
Have you
Annexure
filed
2, I have given FIR against them.
Where is, you have not filed petition for quashing of that?
You will come after that, after this.
Have you filed it? Because there the offense is,
My lord and friends appear on behalf of the opposite partner to informant.
that's right, there are cross FIR, though why don't you file the other petition for the purpose of filing, quashing the other FIR? Huh? କେବେ
File କରନ୍ତୁ ଆସନ୍ତୁ ଦି ଜଣ
କରିକି ଦିଟା ଲଗାନ୍ତୁ. The counsel for the petitioner submits that
Milord,
submits that there are 2 FIR, 2 cross FIRs.
7.
One filed by him against the opposite party number 2, and the other filed by opposite party number 2 against him. Both the FIRs are annexed as annexure 1 and 2. Insofar as the present petition is concerned, the prayer is for quashment of the FIR number 298, 298, number
297.
298 of 2023. Prayer reading, don't. However, however, he has not filed any petition for quashing of FIR 297 dated so and so. Annexure 2 full stop. Full stop. Since the parties have now settled the dispute and have filed a joint affidavit before the court, he seeks time to file a separate petition so far as separate petition regarding the quashing of FIR number 297 of 2023. The same may be done within a week. Let both the matters maybe
Till then, no course of action shall be taken up.
listed before. Hold on. Let it be on 30th.
Milord, till then, no course of action shall be taken up because the petitioners are 17 years old.
What is the offense?
Offense, milord, tribal by magistrate 341. Only 506 is the principal offense.
You have settled the dispute, na?
Yes, milord.
Settled, na? Right. Full stop. Next paragraph. IA you have filed, na?
Yes,
In view of the fact that the parties have settled their dispute and have filed a joint affidavit dated, what is the date? Where is the date? Wait, witness me, 1/1/2023, 2023. The proceeding pending before the Court of Land ATGM Chhatarpur in PS case in GR case number 1150 of 2023, arising out of PS case number so and so, is stayed till further proceeding, till further orders. Take on record. File immediately and check both the matters.
My learned friend will file.
File jointly file.
ଯାହା ତୋର ବୁଝାବୁଝି କରିବ ଆଉ କଣ ଅଛି ବା। ହଁ।
I have stayed the proceeding, file meanwhile, and if you can file little early, mention it.
Yes.
No, great.
I'll take up next day and finish it up.
Both the
File
cases
it.
will be taken up.
File tomorrow, day after, any time, and come and mention so that we will do it.
ଯାହା ତ ଭାଗ୍ୟ ତ ଭଲ।
Yes.
This is Belgium matter. NBW dated my lord 18/12/2021, my lord. At page 9, my lord.
What is the offense?
That offense on section, my lord. So 467, 468,
yeah, okay.
420, my lord.
When was the bail granted?
My lord, bail was granted, my lord, on 28/2/2002, my lord. At page 8, my lord.
Petitioner is one of the accused in the CT case number 1105 of 1999. He was 99. He has been granted bail by order dated
Order dated 28/2/2002.
28/2/2002 by the learned STJM
Baleshwar.
NBW court rate.
18/12/2021. NBW dated 18/12/2021.
Full sir. The petitioner failed to appear before the trial court on 18/12/2021, leading to issuance of the order of NBWA against him. Full sir. Therefore, he is assailing the same. Full sir. Assailing the same in this petition. Assailing the same in this petition. Taking the next paragraph, taking into consideration the facts and circumstances of the case, the order dated 18/12/2021 is set aside, and petition is directed to surrender before the jurisdictional court and appear before the court as and when directed by the trial court. Disposed of. Next.
Obliged.
Item 18.
What actually?
Passing by FR on the ground of compromise.
What ground up?
On the ground of compromise. Now
Of-
the petition-
offense?
Offense matter, no?
Affidavit this
Offense, 354, 500 and other offenses. Now the petitioner number 2 and petitioner is the victim were married and
I am appearing for the informant, my lord, for the petition OP number 2 and 3. 2 is the mother who has lost the affair, and 3 is the victim girl. And both of are married and blessed with a son, my lords.
Bonamali Bari.
Bonmadi
is the son. The son and
is the father.
Devendra Bari
Devendra Mari is the husband.
is the and,
Husband, my lords.
and Pragya is
As the informant, man, that the victim girl,
Victim
Pragya Singh.
who is the informant?
petitioner
Informant, 2, my lords, mother of the
Surya Gandhi Singh. OP2.
You have filed joint affidavit.
affidavit I have filed, my lords.
Have they appeared in the
Appear if my will say,
Huh?
they will appear.
Huh?
They
The date be fixed.
fixed my say will
Let
come
them to appear before.
tomorrow?
tomorrow.
Day after?
It's my lord.
Day after first item.
Jharsuguda Monday.
Jharsuguda to Kono. Monday.
Monday.
16th. On 16th, okay?
16.
16th first item.
Yes, my lord.
Item 1.
Yes.
16th first item.
Both the mother and daughter will come.
Next.
Made, please, my lord.
Yes.
Lord petitioner, I may be permitted to move this application. The petitioner seeks to challenge the order of cognizance taken in a complaint petition, that is a protest petition arising in this case. The fact of the case is that I have got my own industry. I have engaged a contractor. Contractor in turn has placed certain purchase order to somebody else, who is the informant, complainant in this case. Then there is a difference in dispute. There is a dispute in between them regarding payment of money. He says that I have received so much of money and so much of money has not been paid. Then he filed a complaint petition initially. The land magistrate directed for inquiry under 156(3). Then police submitted a final form telling that no offense is made out against the.
Then he files the protest petition, cognizance is taken now.
Cognizance is taken, below.
And was there any settlement, was there any agreement regarding the dealing?
In between me and the contractor, there was a dispute. Ultimately, the matter was referred to arbitration, and arbitration the matter is settled and entire money paid to the contractor. Now, this is an arm twisting tactics, Lord, in order to realize money, not from the contractor, by the subcontractor directly to me, and the only allegation is that the materials has been used in my plant. How can that kindly have a grant to
let us see the allegation.
Your Lordship may kindly see page 127. That is the protest petition.
Yes.
May I draw your Lordship's kind attention?
147.
127.
Yes, 127. Yes. You are the accused persons. You are Mr. Sanjeev Khanna.
Yes. I am for the directors of the company and the
That is-
directors.
KSS Petron.
Mela.
You are the
Jindal Mela.
KSS Petron.
JSS Petron is the contractor.
Yes.
Mela,
And you are for the directors of KSS Petron.
no. I am not for the, I am the director of the Jindal Mela.
Okay. 4. Accused 4.
Mela.
And KSS Petron is the original, what you call the contractor.
Contractor with whom the informant has dealings.
Dealings. The Saha agency has a dealing with the KSS Petron, and you are the subcontractor.
No, I am the Jindal Miller, I am the principal Miller.
Okay.
In my plant, the materials has been used.
Okay. Let us come. Let us come to the-
127, that is the protest petition.
Yes. Para 3.
B. For that, the investigating officer failed to appreciate the fact that though all the materials as required by the accused persons have been supplied and invoices raised.
Where are you reading, sir? Where are you reading?
127 B, Miller, ground B.
127 is something else.
It's 9.
This is, just check it up. 173 something else.
Consolidated.
127, na?
Yes, sir.
It's a copy of ICC number.
125.
This document annexure 11 you are talking about?
Yes.
It starts from 126.
Yes. 126.
And
start.
127.
Huh?
Okay, 128 maybe. Para?
B.
Yes, Parabi.
For that, the
Okay.
investigating officer failed to appreciate the fact that though all the materials as required by the accused persons have been supplied and invoices raised from time to time and admitted the due of rupees was left unpaid to the complainant, so when the accused, all the accused persons are liable for the offense of cheating under the IPC. I don't know from VISOs to Palinkar, it is settled that the intention from the beginning is Not that the offense under the.
If the money is recoverable, the process is something different. You can't,
Then civil law, for that it is a settled proposition of law that an act can give rise to a civil as well as a criminal proceeding. Then he says that.
that's right, that's the general principle he's
That
talking
is
about.
the principle.
Yes.
But here, thereby indirectly admits that it is a civil claim. Then, my lord, 131, my lord. Lord, has your lordship got?
Yes, yes.
131, my first sentence beginning with 2. To
Yes.
make it clear that now the complainant cannot go to the civil suit to claim a legal duty because it is barred by law of limitation. If it is barred by limitation,
So therefore you file a criminal case.
that is realizable by the criminal case law. And the 76 Supreme Court, and then I found a decision in Maharashtra law reporter that it says that in a protest petition.
A ground P, you just come, read the ground P. Ground P. For that, showing the fight between JITPCL so-and-so Petron Limited and taking this name of arbitration between them,
Not
not paying the legal dues of the complainant. The valuable right has been snatched away from the complainant to make it clear that now the complainant cannot go to the civil court to claim the legal dues because it is barred by law of limitation. No money claim can be raised after the expiry of 3 years limitation, and the accused person so and so. So 3 years is passed, so I have no remedy. So therefore I filed a criminal case. That's what he says.
That is the case.
Chalo, issue notice to the opposite parties. Opposite parties. The petitioner has filed the present petition seeking interference by this court under inherent jurisdiction of this court under 482 CRPC to quash the order dated 16/8/2023 passed by STJM Angul in ICC case number 724 of 2015, taking cognizance of the offence under section so and so against the petitioner and issued the and issuance of summons to appear. It is submitted by the senior counsel for Mr. Mohanty for the petitioner that initially 156(3) was invoked by the complainant for registration of the FIR through the magistrate. After having the FIR lost and investigation was concluded and final report was filed. Final report was filed. Against the final report, the complainant has filed a protest petition. The cognizance has now been taken by the impugn order in the state protest petition, and summons have been issued. Petitioner is agreed by the said order and assailing the same in this petition. Issue notice to the opposite parties number 2 and 3. Opposite party number 2 is the informant of the complaint in this case, whereas opposite party number 3 is co-accused with the petitioner. You must be asking for stay, obviously. Good, sir. Next follow. The senior counsel, Mr. Mohanty, seeks stay for the further proceeding in this case.
So far as the petitioner is concerned, letting proceed.
So far as vis-a-vis the petitioner. Good, sir. He, in order to press his application for stay, he has pointed out the grounds taken by the complainant in the protest petition. The petitioner is specifically, the complainant, opposite party number 1, has specifically averred in the protest petition that since he has no remedy of recovering the dues, as the dues has become time barred, therefore he has invoked therefore he has set the criminal law in motion against the accused person. in view of the said stand taken by the opposite party in the protest petition, I am of the considered view that the further proceeding in the instant case is stayed till next date of hearing.
That will be ICC number 162 of 2023.
Yes, ICC number, that is your prayer you have written for page 4. Page 4 the prayer, ICC number 162 of 2023. Pending before subdivisional judicial magistrate Hon'Ble in so also. Okay. Give it in March. So and so accept notice for the state, waive notice.
State को गोटे copy.
Copy गुटे दे दो. ठीक है.
Pray for Passover, my lord.
Passover.
Passover.
21.
Order dated 4/9/2023 under challenge, my lord. Petition was on bail, my lord. On 4/9/2023, he could not take steps.
When you got the bail?
Bail, my lord, I have mentioned in.
Bail.
Bail, my lord, para 5, my lord, 14/7/2020.
14?
Arrested and subsequently on 23/7/2020, he has been released on bail.
23?
7/2020.
देखो, by way of this petition, petitioner has invoked the jurisdiction of this court under 482 so and so, seeking quashing of order dated 4/9/2023, whereby the Learned Trial Court has issued NBW against him, isn't it?
My lord.
NBW against him. So the petitioner content that he has been admitted on bail on 23/7/2020. 2020. Ko bail order kahin?
I have mentioned in para 5, my lord.
Accused absent charge sheet वगैरह file
My lord, my lord.
किसी तो file करना खाली FIR लगे दी file करनी.
Para 5 रे mention करছি.
Cognizance
My lord.
taken full stop. It appears from the record that the petitioner was absent on 4/9/2023 when the matter was called for by the trial court. Therefore, the NBW was issued. NBW bracket A against the accused was issued. He is agreed by the said order. Hence this petition. Next paragraph. Taking into consideration the facts and circumstances of the case, the order dated 4/9/2023 is set aside. Petitioner is directed to surrender to the jurisdiction of the trial court and appear before the court as and when directed by the trial. Disposal. Next.
22.
Documents of the. Yes.
On 17th November 2023, the NBW order was issued against the present petitioner.
CBI.
That's all the copy, Lordship.
Yes, yes, Mr. Naik.
Yes, Lordship, your Lordship, even though it's a Belgium matter, yesterday only copy was served to me. Let it be listed next week, your Lordships.
We'll quash it and let him surrender to the jurisdiction.
Yes, your Lordship, but let it come next week, your Lordships. Officially, I need to get a reply because it only yesterday I got the copy. It is only a formality, your Lordship. Then your Lordship may pass any order.
Okay. Petitioner has filed the present petition seeking quashing of order dated 17/11/2023, whereby the trial court has issued NBW against him. When you got the bail?
17/8/2016.
Huh?
On 17/8/2016, I have surrendered before the CBI court, Bhubaneswar. Lordship, kindly glance page 5 and 6.
When you were admitted to bail, that's what I'm asking.
I have got bail. My letter, before the order.
I think you don't have no idea. Full stop. Issue notice to the opposite party, the respondent opposite party CBI, Mr. Sarthak Naik, appear on behalf of the. You have not implemented CBI. You have implemented state authority.
CBI court, my lord, CBI court.
Who is prosecuting you? Who is prosecuting you?
My lord.
Who is prosecuting you? State is prosecuting or CBI is prosecuting?
CBI, Union of.
State police is not prosecuting you.
My lord.
So if the CBI is prosecuting you, you should implicate CBI. You have not
My lord.
implemented.
My lord.
Somehow Mr. Naik got the notice, therefore he is appearing. These are the, minimum thing you have to do. You have State of Orissa. State of Orissa is not prosecuting. CBI is prosecuting.
Republic of
Next
India.
one, on behalf of CBI. Although CBI is not implicated in this petition and State of Orissa is implicated instead of CBI. Having said that, the CBI, Mr. Naik seeks 1 week time to respond to the petition. The prayer is allowed and matter is now adjourned to. When do you want?
Any date after 21st January.
21st.
It's your money.
29th?
29th, yes, your lordships.
29th.
Sunday.
He's asking no course.
Kichu abani.
He's so confidently saying kichu abani to avani to chalo. ठीक है. Anyway. Yes. Yes. NVW.
Compromise.
Compromise
Question.
Quashing. That they had filed a compromise petition before the trial court. And your lordship directed me to take out notice. Since notice is sufficient on my wife, ex-wife rather.
Who is appearing?
Yes, Sinaj.
The compromise to the no asli kim kuriya.
Nahi, your lordship mein quasi to. Actually, all records are there. All records are there. तोड़े जो फाइल ही तिला those things are there now. Let me place it, your lordship. Bhubaneswar, she had filed a case for divorce that ended in compromise on receipt of 10 lakhs. She had also filed an application to one criminal case. She also filed there an affidavit, and accordingly we got bail and all that. Now that case is still continuing. I have come for quashing of that criminal case. In support of that, we have filed some documents before the court below. That also I have annexed. First of all, your lordship may kindly look at
what is this judgment? Judgment is divorce.
Judgment is divorce.
Where does it say that you have settled the
page 17?
Okay. Yes. Para 7.
Para 7, that it is extremely difficult both the parties to live together, husband and wife. This apart, all attempts to restore irretrievably have no child out of wedlock. 10 lakhs from the respondent, permanent. Considering the pleadings, nature of evidence, record taken. Considering that both parties need to be separated from each other, betterment of goods, and it is failed that allow the prayer for petitioner dissolve. That is dissolution of marriage. Broken down irretrievably.
It is not mutual 13B. It is
yes,
as a contested petition. Somehow the court has passed the. Where is the reflection of the fact that you have settled?
Page 15.
15.
1-5. This is the petition filed before in the criminal case.
No, the petition 15, 1-5, no?
1-5, sir.
1-5. 1-5.
Para 2.
Para
2. 3.
3, yes.
That during the pendency of the matter has been amicably settled between the parties and basing on the compromise, the informant has received 10 lakhs in shape of demand draft such and such.
Where? 15, there is nothing 15. Where is it?
Page 15, sir, Annexure 3.
Annexure 3. That is, it starts from page 12.
Amoro.
Petition to accept the compromise.
Yes, your lordship. Let me place it, madam. Yeah. That the informant, that the case is posted for appearance of the accused person, that the informant, being the petitioner, has filed a petition under section 13(1)(a) Hindu Marriage Act against her husband, namely such and such, bearing CP number such and such before family judge Bhubaneswar. That during the pendency of the case, the matter has been amicably settled between the parties and basing on the compromise, the informant has received 10 lakhs in shape of draft bearing number such and such, Kotak Mahindra Bank Limited, from her husband, namely such and such, as permanent 11, for which the informant does not want to proceed with the case any further and wants to withdraw the case. As such, the interest of justice in compromise petition kindly be accepted. This was filed in the criminal case.
Which criminal case is this?
CT 2228.
That is DBA.
This is the, no, that is 498A.
Okay.
This is,
The
that is
same FIR.
one FIR. One FIR.
The same FIR which you have
Yes,
taken
which I am questioning.
and then what happened to this?
This on joint petition was filed, that is there in the court.
Since it is not compounding, so therefore the
That is
trial
the
court
problem.
can't do anything.
Yes.
Okay.
Both parties have filed affidavits.
Why she is not coming here?
Sir, she is possibly not there. Married and one else.
The service report, just check it up, service report.
ତାପରେ ସିଏ ଆଉ ଗୋଟେ affidavit ଦେଇଛନ୍ତି ଏଥିରେ. She has mentioned during pendency of the driver proceeding, I shall withdraw the criminal case bearing number such and such. Previous page, if your lordship will look at.
Huh? Item received. Receipt. Same address. Item received. Likho. The petitioner has invoked the jurisdiction of this court under section 482 CRPC, seeking quashing of FIR number so and so in city case of so and so. Okay. On the ground, full stop, on the full stop. The Mr. Shodangi, next problem, Mr. Shodangi, Land Senior Counsel, along with Mr. So APS on behalf of the petitioner, and submits that the parties have this dispute is arising out of a matrimonial discord, and the parties have settled their dispute amicably. On the last date of hearing, that is on 3/1/2024, notice was issued to the opposite party number 2, the wife of the petitioner, who is the wife of the petitioner, who is the informant in the present case. How, despite the fact that the notice has been served on her, she chooses not to appear before court. The Land Senior Counsel, appearing for the petitioner, takes me on the record, to the record, and points out that before the trial court, the opposite party number 2 have moved an application, joint petition, a joint affidavit, and this is an application. What is this? Petition to moved an petition.
Parties had
jointly moved a petition before the trial court in the instant case, recording their settlement, and requested the court to drop the proceeding. The annexure, what is this? The said application, joint application moved before trial court is placed before this court, placed before this court in this petition as annexure 3. Annexure 3. The trial court could not have disposed of the could not have dropped the proceeding on the basis of the prayer made by the parties, as the offences are not compoundable in nature. Next paragraph. The learned family court Bhubaneswar, by taking into account the fact that the parties have settled the dispute, have also passed a decree of divorce on 19/8/2020, this which is placed on record as annexure 4. Annexure 4. The petitioner, how much you have paid?
10 lakhs.
The documents are placed on record to substantiate the fact that the petitioner has paid 10 lakh rupees to the opposite party number 2 towards the permanent alimony. Next paragraph. Taking into consideration all the aforementioned facts and circumstances, and this court is of the considered view that there is a fit case where inherent jurisdiction of this court should be invoked. The Mr. Ragada appears for the opposite.
Last
party.
occasion, my lord, the IO directed to take instructions regarding mutual, and he has instructed that matter has been over phone, contacted of the operator to over phone.
So appears for the state. On the last date of hearing, this court has directed the investigating officer to ascertain the factum of settlement between the parties. Land counsel for the state submits that he has sought instruction from the concerned IO in this case and ascertain the fact that the parties have settled their dispute. Taking into consideration the aforementioned facts and circumstances of the case, the FIR number so and so, and the consequential proceeding FIR na CT case number so and so, and all the consequential proceeding arising therefrom stands quashed.
My lord, instead of IO, you also may mention IIC.
IIC.
IIC Mahila PS Bhubaneswar.
IIC
Mahila PS Bhubaneswar.
Mahila Thana.
Mahila PS Bhubaneswar.
Mahila PS Bhubaneswar.
IIC, yes.
ठीक 24.
May I please? Last occasion, these are the, on behalf of Dr. Vinod Mishra, I may be permitted to argue.
What happened?
On behalf of Dr. Vinod Mishra, he is out of station, for which I want to argue this.
Oh, who stopped you? Are you? I thought you were seeking adjournment. Are you?
These are the in-laws of the complainant.
Sukanya Mishra
And
Manas Kumar Tripathi.
yes,
Yes.
they are
Kalpana
implicated in GR case number 846 of 2020. And
Yes.
charge sheet submitted, they are not charge sheeted accused persons. Last occasion, your lordship has how these petitioners are implicated. I gone through that one CC case was filed. That was cognizance was taken. He is staying in USA, so could not get the. I may be permitted to withdraw this application and file better application. Because
Let counsel for the petitioner seeks to withdraw this petition so as to file a better one.
yes,
So as to file a better one. The permission is granted. The petition stands withdrawn with the liberty as bread. 25, huh?
That's item 25, praying for an adjournment.
Adjourned, February. Next.
26.
Kindly pass, kindly withdraw. Withdraw.
Withdraw. Tell properly, you want to withdraw the petition?
Yes.
Memo?
Memo is there.
Memo, withdraw. Here. Next.
27.
27. Huh? Pass over.
28.
Item 20 not placed.
Huh?
Not.
No, you have a wakalatnama in this case.
On behalf of SK Bhanjado. Memo file.
Memo you filed. Acha. Not placed. Memo file. Huh? Memo dekhi nahi. Next.
29.
Pass over. Okay.
31.
Praying for adjournment. Praying for adjournment.
Adjourned. You adjournment to February 2nd will be.
32.
Yes.
33.
33, my lord, kindly send the note sheet. The notice was done from opposite party number 2 on notice.
Postal tracking report of the notice issued operated by.
You have settled the dispute, huh?
My lord.
Have you settled the disputes?
Dispute settlement. A dispute settled.
Why are you surprised? You are not expecting this question. Why are you so surprised? I am asking whether the disputes are settled between the parties.
My lord.
Because I have stayed the proceeding means that must be dispute settled. Otherwise, I never stay the proceeding. Therefore, I am saying.
Dispute settled the
And
parties.
where is the tracking report? Just see. Out on delivery. Item received. So, nani? No, out for delivery. हाँ delivery ही नहीं हो. Put it on 30.
Interim order continue.
मैं first week, second week कर दिया. Seventh कर दिया.
I move to pardon. That item 31 I have wrongly assumed. I thought it to be item 35. I have two items. Wrongly assumed. I want to argue that matter. Item 31.
31 you are not called. Why?
The wrongly I have read for adjournment.
Which one you want to the urgent?
Item 31 I want to argue.
The urgent?
No, I want to argue. I have wrongly prayed for adjournment. I thought that the file is not with me. I have wrongly.
Password. Oh, look. Next.
34. 35.
35 I am praying for adjournment.
Adjournment.
Okay.
You wanted 35 adjournment,
Again,
31 argue.
again.
Reverse कर दिया.
Okay.
Okay. Adjourn.
36.
Permitted to withdraw.
Withdraw. Memo ले लो, withdraw करो.
37.
I am for the informant, man.
Who is for petitioner? Basu. 37. 37. There are 2 weeks time for next 38.
38.
38 US.
Yes.
Okay. Savitri Manti.
Yes. For 5 accused persons in this case, in that case, typical number 757 of 23. 5 accused persons, out of them, for 4 persons, Savitri Manti, Tapasuri Manti,
Right.
Sanatan Mahanti and Subhash Chandra Mahanti, I am filing this petition. 36. They are under section 498A. 38.
Who is the informant?
Yes. Informant is History for our complainant.
You have not implemented.
Pardon?
You have not implemented here.
My name?
You have not implemented the informant.
My informant is History Baral.
Then
Sorry.
how can it be passed?
Sorry, Your Lordship.
Let counsel for the petitioner seeks time to implead the informant in this case. The liberty is granted to him to implead the informant in the present case. Matter is adjourned to February 2nd week. Passing of FIR in 498A and all, you don't implead the wife.
Oh, yes. Sorry, Your Lordship.
Then how can it be passed?
February.
Next.
39.
Yes, passing of criminal proceeding, my lord. On the ground, my lord, in similar fact and circumstance, my lord, co-accused person who faced the trial, they have been acquitted by the Court below, my lord.
You are absconded.
Absconded.
Now you become a vicar.
My lord. My lord,
That's very.
this one, in similar fact and circumstance, my lord, this honorable quash the proceeding.
What is the offense?
Offense, my lord, 395 here. My lord. I have annexed the judgment and deposition, my lord. No useful purpose will be served along the criminal proceeding. my lord.
Charge sheet has been filed against you.
Yes, ma'am.
From you were on bail.
No, no, ma'am.
2 months, 3 months. 2 months, 3 months. How much?
3 months.
3 months. Take counsel for the petitioner has filed this petition. Seeking quashing of the FIR, quashing of the criminal prosecution launched against him by the opposite party number 2 under PS case number 6 of 2014, corresponding to GR case number 51 of 2014, pending in the court of SDJM Koraput.
Yes.
Full stop. Charge sheet was filed in this case, whereas the petitioner was absconding. Therefore, the other co-accused persons, those who have surrendered to the jurisdiction of the court below, that is, how many accused?
5 accused, ma'am.
Had other 5 only. Charge sheet was filed. Other 5 co-accused persons, those who were charge seated along with the petitioner, were subjected to trial. By the judgment dated, which is the judgment dated by? Judgment dated 31/10/2016.
Yes.
2016.
Yes.
All the accused persons have been acquitted by the learned court of what is that?
Additional section just Koraput.
Additional session says Koraput. Koraput, full stop. Relying upon the said judgment, the petitioner.
Premanand Sahu of the state of Orissa. This honorable quash the proceeding.
All right, but you contact Jesse. 2016 they were acquitted. Jolly well we are enjoying. You want to take advantage of your own this thing. See, then these 5 accused were fools.
No.
They face. And you enjoy it. Won't face. That is why 3 months at least. You get the bail also. So that judgment, you get the bail.
Your lordship indicate that.
Said judgment, the petitioner has now filed this petition seeking interference of this court under section 482 CRPC. He pulls up. Mr. Mishra, learned counsel for the petitioner, relying upon this is which para?
Class item ଟା ବୋଧେ କହୁଛନ୍ତି ଆପଣ.
Relying upon the judgment of this court reported in 2013-54 OCR 544, that's Premanand Sahu versus State of Orissa, and contains that in the similar circumstances, this court has invoked the jurisdiction of 482 CRPC and quashed the proceeding. In this case, what had happened? See, on 11/5/2011, Mr. Mishra, this judgment will not help you in the sense. On 11/5/2011, the people were acquitted. And in 2012, immediately, this accused came to 482 court. What have you done? 2016, now 2023. Okay.
Lost some unknown person, my lord. That is, FIR was lost some unknown person, my lord. I am unaware of that, my lord. Whether any case.
Charge sheet was filed against you.
Yes, charge sheet was
Then
filed for-
charge sheet
I
was
was
filed.
unaware.
What is it? I have perused the document placed on record and evaluated the judgment cited by Mr. Mishra. Having taking into consideration the fact that the acquittal order recorded by the court below on 16, what is that date? On 2000. 16, over 2/4/2016, and the petitioner was absconding throughout. I am of the considered view that the criminal prosecution by invoking the inherent jurisdiction should not be quashed. However, the petitioner is granted liberty to surrender before the jurisdictional court within how much time?
Within 15 days.
Within 15 days. 15 days. And sought for appropriate direction in regard to the enlargement of bail and face the trial. The trial court is directed to dispose of the trial as expeditiously as possible, not later than 3 months hence from today. 3 months hence from the date of surrendering.
From the date of
surrendering. 3 months hence, not later than 3 months hence from the date of surrendering.
Bus.
Bail.
Bail you get. So this bail you get. Acquittal, the cause persons are granted acquittal. Immediately you get the bail, and no further evidence is also required.
They will not, unless a direction, my lord, they will not consider the bail application since the.
Then stay 3 months, you enjoyed for such a long time.
That part your lordship objected.
The counsel for petition submits that he would be moving after surrendering to the jurisdictional court. He would be moving a application for grant of bail. The bail may be the bail application moved by the petitioner may be decided by the trial court on its merit without merit as expeditiously as possible. With as expeditiously possible.
Lordship may indicate a co-accused person also enlarged on bail. Co-accused person enlarged on bail.
They are acquitted.
No, prior to that, my lord, they were released on bail.
Oh, that you argue there. That is the merit you have.
Unless
They were also granted bail. They faced the trial. They got acquitted. And you charge sheet was filed. You were absconding for how many years? Just see. So once you are once these kind of petition people are granted bail, then the jolly well he will escape. Then the trial court will keep on waiting for you. Better that you surrender, face the trial and finish it up, come out. That's the best way because you get acquitted. Because no further evidence is required. The prosecution will choose those evidence only. So therefore, it is easy for you to get out. Yes.
Item 40.
On behalf of Mr. D.R. Sundarai, may be taken up next week.
Copy may be served.
Copy, served the copy.
Goes with the
Yes.
41.
Please, your lordship. Lordship, the petitioner challenged the FIR and the total proceeding by the Barang PS case number 64 of 2022 and in connection with the GR case number 831 of 2022 under section 52A of Odisha Excise Act.
Odisha?
Excise Act.
Okay. What is the ground?
Ground that the petitioner is not present at the spot.
Oh, that is a matter of trial.
And the one ASI MK Mahapatra on 3/4/2022 at about 9:30 PM, along with other opposite official staff, seizure article to PS and present a written report that
Charge sheet is filed.
charge sheet is filed.
Where is charge sheet?
No, charge sheet
You'll also may kindly turn to page 3 of the petition, para 4. Para 4. What he has stated that it is respectfully submitted that it is a crystal clear that the petitioner, as per order of the Hon'Ble High Court of Odisha, by the ABLPL number
The
6.
petitioner, as per the order of court, fail.
When go
Surrender.
to surrender before the court of the JMFC, 2, then the counsel of the advocate not press the petitioner as the learned court below denied to release the petitioner on go on bail. It a con mu kichi bujhpa.
Are you on bail? Are you on bail or not?
I am in bail, my lord.
What is this then?
Before anticipated, the petitioner filed anticipated bail before the Hon'Ble High Court. And when he go to surrender before the court say the lower court said that judicial custody ko jibo. Mu bail debini. And then the petitioner not press the order. And I have.
You tell, no problem. I understood what you are
And
saying.
also thereafter in another case, then he was arrested. ଏଇଥିରେ ତାର କିଛି ନାହିଁ ଭୂମିକା ନାହିଁ ନା ସେ ଯୋଉ କହୁଛନ୍ତି he is the driver.
He was arrested in another case, and in this case also he was taken into custody.
In this case, on that case, ଏଥିରେ remand ହେଇକି ଆସିଲେ.
But you want quashment of this.
Before filing on that case, এটা file ହେଇଥିଲା before arresting the case.
Will you withdraw the petition to argue all this point at the time of framing of charge, or I'll dismiss?
On the lower court below, I have submitted my lord.
You have come against the order dated quashing of the proceeding. Dekho, the land counsel for the petitioner, charge sheet has been filed? Yes, charge sheet has been filed or not?
I have no knowledge, no instruction, my lord. खाली bail ହେଇଛନ୍ତି ସେଥିରେ, but till at a date is not.
ଆପଣ ଏଇ stage ରେ ଆସିକିରି why are you prejudicing your client?
My lord, ଏଟା 23 ରେ file ହେଇଥିଲା.
Dekho, the petitioner is by way of, in this petition, the petitioner is seeking quashing of the criminal prosecution against in PS case number so and so. This case, the investigation is still on. Since the matter is since the petition is a premature petition, the counsel for the petitioner seeks to withdraw the same and reserving his rights to agitate the issue at the appropriate stage in the trial. The petition is dismissed, granting the liberty as spread. Yes. 42.
Number 39, madam. I seek
Item?
Item 39, madam. Your lordship may indicate that, my lord, the bail application shall be disposed of by both the court on the same day, my lord. Since it is a sessions tribal court, my lord. A commitment has not been made. Now
Yes,
the
yes.
case is under split up.
Sessions tribunal magistrate cannot dispose of on the same
Your
day,
lordship
both
may
the courts
indicate
shall
that
dispose of
same day
the
both the courts be disposed.
What have you written? While I'm on it.
Yes.
42. Mona put it, 39. Yes. 42. Pass over. 43. Yes, 43.
Copy not, sir.
You are referring to pass over.
So it is CB.
44.
May I please, Your Honor?
Yes.
My lord, this petition is directed against a refusal to release my cash security when the case has been accused is dead and it has been acted.
Case has been?
Case accused, after death of the accused, the case has been abrogated before the trial. Thereafter, the legal head
with the succession certificate, approach the trial court for release of the cash security. But that having been rejected, I have before your also. So the facts are like this. My lord, the petitioner's father.
Is there any other accused
Other
co-accused
accused
person?
persons are there. But so far, my father is concerned, the case has been abated. That is there in the.
That may be abated, but the other accused persons are there. It has to subject to trial.
My lord, that was the cash
Yes.
security.
And criminal conspiracy may be proved also, your
Bail
lordship.
order.
Yes. It was not compensation or anything else. It was,
Cash security because you might have cheated people.
No, that is true,
Ah,
but the case has been terminated. The case has been terminated. So far, mine is concerned.
It is abated.
Yes, it is abated. So, it cannot be, my father cannot be, it cannot be tried against a dead person.
That's right. That is the reason it is abated.
That is the, and so, once the case is terminated, even if there is a conviction or acquittal, the bail bond is automatically discharged, my lord, after the termination of the case. As you also know that is the criminal judgment.
How much you have deposited?
1 crore. 1 crore I have deposited.
You are the main accused.
No. I'm one of the accused.
What about the other accused persons? Have they deposited money?
That other accused persons are on bail and some have deposited cash security and the case is going on against them. But
Let Mr. Naik file the reply.
the reply has come.
Okay.
That
Where is
The
that?
reply has been filed, your lordship.
The reply they have said that the case has been abated, that no offense is not. My lord, and it may be utilized for the purpose of compensation. Your lordship may kindly have a glance to 357.
Okay,
After
so-
conviction, the compensation will be.
That question comes after the trial is over.
Yes, your lordships.
Trial is over, qua the other.
No. Conviction.
Yes, your lordships.
Just a minute.
Yes, to कहले कौन कहले?
So far me is concerned, my lord.
You will never be convicted. That's
I will
different.
never be
That's sure. But
It is mine, it was deposited in respect of what? It was deposited in respect
in
of.
respect of your liberty, it was the money was deposited in respect of your liberty. Okay. You got the liberty, somehow you expired.
So
But
now-
that money will be utilized after the final outcome of
How
the.
can it be? How can it be? It will be utilized. It is the money of one of the accused against whom trial cannot be done. Now, no trial can be proceeded. So how can it is, my lord,
Let us see the reply.
yes, reply your lordship may kindly see paragraph 17 and 18. And 15 and the rest of the reply are on based on facts of the prosecution case. 17 and 18 of the reply your lordship may kindly see. That the contention of the petitioner in paragraph 5 regarding the trial as well as abatement of the case of the accused Tapospal as a matter of record. It is in this regard, it is submitted the case against accused Tapospal as abated only with the regime that the accused passed away on 18/2/2020, and this way the accused is not able to face trial in the court of law. However, public at large was defrauded by deceased accused, namely Tapospal, criminal conspiracy with other accused persons who are still to face trial. The observation of the trial court with regard to trial, while rejecting the petition, the petitioner is misconstrued and hence need no interference. Then the next part, that the contention of the petitioner in para 6 and 7 are objected. In this regard, it is respectfully submitted that this honorable court that the accused died, but the offense not. Moreover, interest of the aggrieved investor paramount importance who have invested, lost their hard-earned money in different Punji scheme operated Rose Valley, promoted and by the accused, and grave impression that believe the business of Rose Valley and the genuine of the blessings and government, thereby the money invested.
Who are you? Who are you?
I am the daughter of the IDC.
No, the accused, your father.
My father was one of the director of that.
Which Rose Valley?
Rose Valley.
He was a member of parliament, your lordships.
Your lordship may kindly see. My lord, the case.
What is the extent of
My liability was 26 lakh.
No, the scam, your lordships, is the 17,000 crores, your lordships.
Rose Valley, how much?
17,000 koti, 17,000 crores.
17,000 crores.
Then one crore,
No,
nothing.
that is my money. That is my money, my lord.
Your money you have collected from the
Proceeds of the crime.
My lord, your lordship may kindly have a glance to the bail order. It was not.
Let us see the bail order.
Huh?
See the bail order.
Yes, your lordship may kindly see the bail order. The condition was to deposit in respect of the cash.
That's right. That is the reason. See, the generally
It was not for the purpose of compensation or
See, I'll
anything.
tell you, generally, the cash surety while granting bail is
My lord,
not basically tenable in law.
Yes.
Courts are not happy with it. Supreme Court is not happy with this conditional bail with it.
My
But in Ponzi scam,
No, my lord.
it is the Supreme Court who has
Yes, yes.
Yes, your lordship.
imposed
How
it.
can a dead person's money will be utilized even if there is a conviction in respect of other activities?
That is what the trial is, whether this money is your money or you have collected the money.
Yes.
No, no, that
Yes,
is
your
not,
lordship.
no,
That
no,
is the trial.
no. The cash security, my lord.
That's right, I understand it.
My lord, let it be
But-
adjourned and I will.
No, your lordship. It can be disposed of, your
Let
lordship.
us see your this thing. Let us see the bail condition.
Yes.
Hmm.
It was only a.
And then the trial court reasoning. Bail condition.
Bail conditions. my lord. Your lordship may kindly come to page,
This is the
20.
page 21.
no, not 21, my lord, conditions, my lord. Conditions 28,
28.
para 12.
See, so big a order.
That is the, in respect of discussion regarding merits of the case.
So you are, it is not a simple case, Anyway,
No.
28, that
28,
is
paragraph 12.
accordingly.
Paragraph 12.
Hmm. Directed
Accordingly,
that-
it is directed, let the petitioner be released on bail by furnishing bond of rupees 2 lakhs with 2 solvent surety, like amount to the satisfaction of the learned special judge CBI, subject to the following condition: he shall furnish cash security of rupees 1 crore to the satisfaction of the learned trial court in the suitable terms to be decided by the court. He shall surrender his passport before the trial court and shall not.
Well, these are here conditions.
These are all other conditions. So pursuant to this condition, I deposited, and this is the
You have deposited, there is not a dispute. And what is the trial court says one releasing, this is the order is at page.
trial court,
Your
my
lordship may
lord,
also read, your lordship may also read paragraph 8 of the bail order.
The paragraph
Guru.
8 of the order. Mr. Naik wants
Paragraph
to
8.
Read the order. Similarly, as submitted.
Similarly, as submitted.
As submitted earlier before this court, it was submitted by the Learned Counsel for the CBI that the petitioner.
That the petitioner, with his background as a sitting member of parliament and a film personality, actively participated in the affairs of the company, promoting its affairs, your lordships, thereby gaining the faith and confidence of the general public to invest their money in the company.
And
It was further submitted that Rose Valley Group of Companies has been found to have collected huge amount up to a tune of 17,000 crores. It was also submitted that the petitioner played active role in making correspondence with them, Honorable Finance Minister of India. At that time, it was Mr. P. Chidambaram, and the Reserve Bank of India, and used it as an eyewash to show the public that Rose Valley Group of Companies were dependable companies and they should invest money there. Your lordship may look at the gravity of the offense.
Witnesses under 164 statements were there and able to
Yes.
see.
my lord, whatever it may be, my lord, but now. the
Placing
purpose
statements of some witnesses recorded on 164.
Maybe, because the.
My lord, in that case, your lordship may allow me some time, I will file some judgment. My lord, and after the disposal of the termination of the case, the bail bond is discharged.
That is the settled principle, your lordships.
Theoretically, you may be correct, but in this case, I will not interfere.
No, let me give my opportunity.
See, ultimately, see, the common man's money has been.
That is true, my lord, but how, without, my lord,
And see your position.
Without the conviction.
See your position. You were a sitting MP.
No, that
1 crore will not make any difference
No,
to your
no,
family.
that person is-
But 1 crore will make a lot of difference to the family of the
my
poor
lord,
people.
My lord,
whose
that
money was-
person is dead. No, now this person, this case cannot be against me.
That
Against
is
the
the
person.
only positive point you have
Yes.
today.
So in
To
that
argue
case, that money cannot be utilized in any manner.
What is the stage of trial?
No, trial has not commenced.
It's a
Yes, had there been any conviction, yes, it could have
That's
been
right,
any
that's right.
substitution. But
120B is there, your
cannot,
lordships.
this accused Taposwal cannot be substituted. No,
What are you doing for living?
my lord,
What are you doing for living?
the petitioner.
Hmm.
Petitioner is, my lord, she's doing some advertising and all these things, so. So there.
You should doctor of parliament have a pension.
No, not son, daughter.
Daughter. What about the son?
No son,
Only one daughter.
only one. And myself, my mother. we
And
have
your lordships,
also-
she's the daughter of a parliamentarian.
Just a minute, please.
Your mother is not a party.
No, she has, successor certificate has only been issued against the daughter.
Anyway.
Pension be mile, your lordships, to the
What judgment
parliamentarians.
you want to put?
I have not brought.
He is seeking some time, Mr. Naik.
Lordship, a fixed date,
Which date suits you?
19th.
First week of March.
March.
No, if she is in need of money, your lordship, then it should be listed earlier.
Then-
पैसा दरकार है,
Very
जल्दी
fact
इटा
that
ही
you
जब.
don't need the money, let it be there, I'll dismiss it.
No, so it-
No, let
Ma-
it be on second week of February, somewhere in, because partly I heard it. So
Lordship may also
therefore,
write it part heard.
Let it, no, not part,
No,
but
no, my-
let it be on 15th,
one-
15th February.
No, Lordship, may kindly please. My lord,
15th, I am not there.
you will,
15th.
legally will. It's not that,
Why are you so apprehensive that this court will pass an order, illegal order?
No, legal, what is the legal?
That's what I am considering.
Yes, ma'am. One thing, my lord. I'm sorry, my lord.
If the order which I am going to pass is illegal,
No.
you have remedies available under law.
Yes.
My lord, admittedly, my lord, the father of the petitioner who was an accused, is.
See, you have exercised 482.
Yes.
Remember. And this court can pass any order to meet ends of justice.
Yes.
Ends of justice. So therefore, since you have invoked a jurisdiction,
Yes,
it may be a dangerous jurisdiction for you.
My lord, one thing, my lord. My lord, what is as your lordships know, my lord, in a judgment, when the case is, judgment is delivered, my lord, either acquitting or convicting the accused. What is the law? Well, the law is that the bail, if the accused is on bail, the bail bond will be discharged.
There I am agreeing with you.
Now,
But
I just put it in a reverse way. Suppose this bail order was passed in my favor, the bail order which has been passed in my favor, directing me to deposit security of 1 crore. Suppose I would not have deposited, what would have been the rate? I would not have been released on bail. So staying in custody.
Do you know in this matter,
No,
CBI?
it was not the direction that I have to deposit.
No, I am saying something else.
Yes.
The money collected in this process of depositing and all is being disbursed to the victims.
No, it was treasury challenge, it was deposit.
But it is there.
No, it was not a condition that it will be disbursed to any.
Where the court finally will decide.
And there is a committee also, Lordship, MM Das committee, Honorable Justice.
Basically, this is not your money.
No.
Yes.
The court said it is a condition so far release of the person. Court has not said that it is.
Sir, I understood this much. I understood. You are telling the same thing in different ways, but the fact remains that the money is deposited. You have your father has died. The money was deposited towards the condition of bail,
Bail.
and you say that once it is awaited against my father, the money has to be released. That's what your whole case. The trial court is rejected,
My lord,
and
now the lordship another thing. I had in pursuant to my bail order, I have also furnished two CVT. Now those.
that's the discharge.
No, those have been discharged. So this is also one of the security, my lord. This is a cash security.
You are right there. I am not saying that, but
So all these things, my lord, how, my lord, after the death of a person, how can the money of that person against whom trial cannot be proceeded?
the question which you are putting how, that has been answered by trial court, and you are challenging that.
No.
I will answer that also.
No, trial court said that it will be utilized for the purpose of compensation.
Maybe
Compensation question where it will come. My lord, it will-
19th January.
Compensation question 357 your lordship. 357 say on conviction, if a fine is imposed or a sentence is passed. So where is the question of imposing sentence in respect of tapos?
maybe the trial court reasoning is wrong.
No.
But
Yes, my lord.
Okay, will you satisfy? I'll set aside the reasoning, but I'll maintain the order. I'll set aside the reasoning. Reasoning is wrong, maybe.
So
But
that will be.
Your lordship.
whatever, that you leave it to me, that how to.
Your lordship.
15th.
15th of?
15th.
15th of February.
15th of February.
First week of February, your lordships. First week of February.
Not first week, my lord. First week, 15th.
15th, let it be 15th, because first week lot of matters I can't.
And your lordship, keep it part heard.
No. Parted, because Parted system, it has no meaning, parted. If
That's right.
you know that, parted has no meaning. I may change my mind, who knows?
না না আমার আছে কেতে এটা পাঁচটা আছে ওটা কেতে সিরিয়াস দেখলে 23 নম্বর আইটেম তারপর লেট
of NI Act, my lord. My lord, under the ground that, my lord, the statutory notice on under NI Act has not been received by the petitioner, my lord. First. Second, the amount which has been inserted. in the-
Where is the complaint?
My lord,
Where is the complaint petition?
and a complaint petition is annexure one, my lord. One CC number.
Where is there any averment to that effect? एक minute.
Yes, my lord, there is our in spite of my lord, pause. My lord, that is it.
No, para 5.
My lord.
Para 5, page 11. Para 5, page 11.
My lord.
It says that the complainant served both the legal notice, correct address of the accused, but the accused knowingly avoided to receive one. So, then it's a matter of trial.
It amounts to service.
Matter of trial.
My lord, the address to which the letter has been issued, my lord.
So these are matter of trial.
He is not residing, my lord. He
Whatever.
is not residing. my lord.
That is
Second
again.
thing, my lord, the amount which has been inserted in the check, my lord, that is not my handwriting, and the amount is.
All these things are different, sir.
My lord, a
Because
notice, notice may be issued, my lord.
No, the petitioner has filed this petition under section 482 CRPC seeking quashing of a cognizance order dated 22/5/2022 passed by Leonard J. MFC Nimapada in ICC case number 103 of 2022 taken against the petitioner under section 138 NI Act. Next paragraph. The Learned Counsel for the petitioner has raised two points, namely that the
Statutory notice.
Statutory requirement of issuance of notice under section 138 Act has not been complied. Secondly, the
Amount
his
inserted.
signature is not appearing in the subject check. Full stop. I have perused the complaint filed by the opposite party number 2 against the petitioner. Para 5 reads as under. Para 5 reads as under. Page 11. Full stop. Insofar as therefore, on the face of this averment, the first ground raised by the petitioner doesn't subsist. Secondly, the contention that his signature is not appearing in the appearing in the check is an issue to be decided by the trial court. Full stop. Therefore, I am of the considered view that at this stage, the proceeding initiated by the opposite party number 2 under section 138 NI Act cannot be quashed while exercising jurisdiction under 482 CRPC. Hence, this petition is dismissed. Next. Needless to say that all the points available to the petitioner. Needless to say that he is at liberty to raise all the contention available to him at the appropriate stage of the trial. Yes.
It is was earlier opposition also. At the time of cognizance, in your lordship page 35, this on input was pleased to dispose of such application with the liberty. So, at a later stage.
The liberty is very dangerous. The liberty means inviting another petition.
Yes.
That's the problem.
Your lordship may, your lordship may kind of a graph to page 11. Initially, the case was registered under section 306 along with offences against 3 accused persons.
Yes.
But charge sheet submitted only against 2 accused persons. May I go to the FIR? Lordship.
You are Udainath Sahu and
Udainath.
Yogeshwar Sahu. Against you, charge sheet is filed.
Yes, ma'am. Bhaveshwar Sahu was not charged sheet. But
Okay.
if your lordship go through the FIR,
Hmm.
may I read my report?
Yes.
Yes, 16, my lord.
Hmm.
ଅଧିନ ରଞ୍ଜିତ ସାହୁ ନୟାଗଡ଼କୁ ଆପଣଙ୍କୁ ଜଣାଉଛି ଆମ ଗ୍ରାମର ଉଦୟନାଥ ସାହୁ ପିତା ରତ୍ନାକର ସାହୁ ତାର ପରିବାରବାସୀ ସାଙ୍ଗରେ ମୋର ପିତା ଓ ପରିବାରର ସଚେତନ ଶତ୍ରୁତା ବହୁ ବର୍ଷ ହେଲା ଲାଗି ରହିଛି। ସେମାନେ ଜୋରଦସ୍ତ ଆମ ଘରର କିଛି ଅଂଶ ଦଖଲ କରିବା ପାଇଁ ଚେଷ୍ଟା କରି ବୋଲେ both the accused ମାନେ present petitioner and the informer are common ancestors।
Okay.
ଚେଷ୍ଟା କରି ବିଫଳ ହେବା ପରେ ସିଭିଲ ମକଦ୍ଦମାରେ ହାରିଯିବା ପରେ ମୋର ବାପାଙ୍କୁ ଏସିଡ୍ ମାରି ଦେହରେ ଦଣ୍ଡିତ ଓ ପୂର୍ବ ଶତ୍ରୁ ଟାଙ୍ଗିଆରେ ଆଣି ପ୍ରମାଣ ଅଭାବରୁ ଖଲାସ ହୋଇଥିଲେ। ପୂର୍ବ ଶତ୍ରୁତା ଯୋଗୁଁ ସେମାନେ ଆମ ବଂଶକୁ ମାରିଦେବା ପାଇଁ ଆଜି 23/10/2020 ମଧ୍ୟାହ୍ନ 12 ଘଣ୍ଟା ସମୟରେ ଆମ ଗୃହରେ ଜବରଦଖଲ କରିଥିବା ଅଂଶର ଷଡ଼ଯନ୍ତ୍ର କଲେ। ମୁଁ ମଧ୍ୟ ଏକଥା ଶୁଣିଛି, ମାତ୍ର ବାପାଙ୍କ କହିବାରେ ସେ ଏକଥା ବିଶ୍ୱାସ କଲେନି। ଦିନ 2ଟା ସେମାନେ ଯଥା ଉଦୟନାଥ ସାହୁ, ଯୋଗେଶ୍ୱର ସାହୁ ଓ ଭାବେଶ୍ୱର ସାହୁ ଏକ ମନ ହୋଇ ଆମମାନଙ୍କୁ ଜୀବନରେ ମାରିଦେବା ଲକ୍ଷ୍ୟରେ ପ୍ରତ୍ୟେକ ଭୁଜାଲି ମାନେ ଧରି ଦାଣ୍ଡ ପଟୁ ଆମ ଘର ଭିତରେ ପ୍ରବେଶ କରିବା ଦେଖି ଜୀବନ ଭୟରେ ବାପାଙ୍କୁ କହିଲି, ବାପା ତୁମେ ପଳେଇ ଆସ। ଏହା କହି ମୁଁ ବାରିପଟକୁ ଚାଲି ଆସିଲି। ମୋର ବାପା ବାଥରୁମ୍ ଭିତରୁ ଘୁଷୁରି ପଳେଇ ଆସିବା ବେଳେ ତାଙ୍କୁ ଭାବେଶ୍ୱର ସାହୁ ଧରିଥିବା ଭୁଜାଲିରେ ତାଙ୍କୁ ପଛପଟୁ ବୁଝିଦେଲେ।
Bhaveshwar Sahu.
he was discharged, he was not charged। ବାବା ରକ୍ତଜୋଡ଼ ହୋଇ ସେଠାରେ ପଡିଗଲେ। ମତେ ମାରିଦେବାକୁ ଯୋଗେଶ୍ୱରକୁ ଗୋଡେଇ ଆର କଲେ। ମୁଁ ଦୌଡ଼ି ବାରିପଟକୁ ପଳେଇ ଆସିଲି। ସେମାନେ ମଧ୍ୟ କହୁଥିଲେ ଘର ଭାଙ୍ଗିଦେଲେ, ଇଏ ଭାଙ୍ଗିଦେଲେ, no allegation। After going through the
This is the allegation. What is the charge sheet?
Charge sheet under section 307.
Where is that charge sheet?
My lord, Annex 3, page 20. My lord, in the charge sheet, my lord, the Bhaveshwar name was deleted.
Dropped.
And only charge sheet submitted against and the weapon of offense is knife.
That is recovered at your instance.
Sahu was involved in this offense should be used in the time of
Then your only ground is, since Bhaveshwar Sahu has been discharged, a closure report is filed in his favor, so we should not be proceeding.
No, 307 matter. My humble submission, my lord, the allegation is that Bhaveshwar Sahu assaulted by Mr. Bhujali. And he was discharged.
But where is the injury report?
Injury report I have annexed.
What is that injury?
My lord, 33, my lord, page 33, simple injury. Hot injury, 2.52, below scapula, simple.
Sustain, serve, person on the right side of the body, is due to assaulted by accused persons by means of what weapon? Page 32, just see, handwriting.
3 my lord, sharp cutting weapon.
Cutting weapon, in view of. Thirty-three.
Well,
very simple, very simple.
simple my lord,
No, whether simple or grievous.
4. 1, 2, 3, 4.
By what kind of weapon? Have you taken any step for this? You have filed the charge sheet.
Yes.
Saying that Bhaveshwar is not there.
Yes.
How have you taken, what is the evidence?
Allegation is that Bhaveshwar assaulted by means of a Bhujali.
Bhujali.
That is not the case. Case is assaulted by means of a knife. So knife seized from others.
Knife is recovered.
Knife is recovered. That is the charge sheet.
27 involved.
Yes, might be because I don't have any copies, but so far the charge sheet is concerned, that shows knife is recovered.
Recovered
rightly-
at his instance or what?
I don't know, my lord. It has been mentioned, the knife has been seized. The seized weapon of offense knife with wooden handle used at the time of occurrence.
Who was holding that knife?
That has not been mentioned in the charge sheet.
You have gone through 161 statement at all.
161 statement is for page 31. Here. When I am reading the relevant person, Dino 2 घंटा समय रे से statement होची चंद्रशेखर साहू page 31. चंद्रशेखर साहू.
Yes.
Dino 2 घंटा समय रे
Chandrasekhar Sahu is one of the son. Who is he?
Yes.
Who is he?
Chandrasekhar Sahu. Chandrasekhar Sahu.
Injured.
Chandrasekhar Sahu is the injured.
Injured, okay.
Injured statement has been recorded. He stated that Dino 2 घंटा समय रे आसामी उदयनाथ साहू ओ तार दुई पुओ भोलेश्वर साहू और जोगेश्वर साहू मिसी आमको मारिबा लक्ष्य रखी पूर्व प्रस्तुति होई भुजले आदि मारणास्त्र धरी आम घर भितर को जबरदस्त पशी आम परिवार को भयभीत करी मो स्वामी को जीवन में मारी शेष करदे आसामी आक्रमण कले मो पुओ रंजित साहू आम परिवार समस्त को बाहर को पळाइबा पार्टी करारू समस्त बाहर को आसीबा बेले आसामी भवेश्वर धरिथिबा भुजले मो स्वामी को तांको पछपटो हानि देबा
भवेश्वर.
यस डॉक्टर भाई सेटा पढिथिले.
How have you exonerated Bhaveshwar?
That is the charge sheet in which
How can you do it? There is specific allegation against Bhaveshwar.
Yes, that is specific allegation against Bhavesh.
Then? And the two people, those who have participated 34, okay, I can understand,
Yes.
but that can't be a ground for quashing. That there.
I got my humble submission. Other offense, I have no case. Other offense are made up. There is an alteration of hot word, assault, 323 is there, but so far as 307 is that fatal blow. It is a simple injury.
The problem is, I'll tell you, if you take out Bhaveshwar
yes,
and invoke 34,
34 is the
नहीं तीन गोटे जन ना
ना और जन 2 जन छन
अच्छा उदयनाथ एंड
जोगेश्वर
भावेश्वर इज exonerated.
35 more other offense so far as other offenses I have no, my lord, it is a matter of trial. So far as 307 matter, 307 assault parties against Bhaveshwar, and Bhaveshwar deleted, the police has deleted the
What the trial court says?
Trial court, my lord, another that point I am raising, my lord. Your lordship may kind of a glance to page 11.
No.
Page 11.
Yes, yes.
My lord, on 1910, since it is a session tribunal, 1910-2023, the case record is received from today on transfer from Sessions Judge Nayagar and taken into file, make the necessary entry, put upon appearance. On the same day, madam, active person named Udayanath Sahu, Jogeshwar Rao present in court, file other, they also file a petition to continue on previous one. Surety such and such, files a memo to stand surety for the active person on being asked, surety they express their opinion, such applicant. According to the petitioner, government period is accepted. Appearance of the active person compared to put up. Later, madam, on the same day, active person are present in court, both the law and FPP defense are present, hard on both the framing charge, active person, peril the FR, police power, documents, other, how can there prima facie well made out, presume that active person has committed 341, 452, 23, 307, 294, 324, 506. There are sufficient material to proceed into the active Udayanath Sahu, Jogeshwar came under the operation in a separate sheet after to display the contents of the above charge are read over and explained in audio. He plead not guilty and no document is admitted into evidence by the accused person 294 CRPC. At this stage, on PP orally sound. So charge was framed.
But by the time the
on my humble
petitioner
submission,
never
on 1910, the case was being received by the session as assistant session. On the same day, charge was framed. As per the provision of CRPC matter 238 and 239, you will also go through that decision matter. There is some breath matter must be given to the accused. So far, your lordship can have us to page 238, section 238.
No, this is after committal proceeding.
Yes, my lord, commitment when
You got the copy, committed, thereafter you decided it.
No, my lord. When committed, my lord, it will come to sessions, my lord. It is a warrant procedure case, my lord.
Where is the proceeding before 1910? You not file that.
My lord, before 1910, it was before the JMFC.
No, where is that?
13, my lord, page 13, my lord, 12/1/2021. That is the cognizance order. It was before the JMFC conference.
My lord,
No, thereafter committal proceeding, where is committal proceeding?
Committal proceeding, I have no.
After committal proceeding, what has happened that has?
Your Lordship,
That is a very weak point.
No, my lord.
Lordship, can you turn to page 36? Page 30.
Yes.
But I'm reading from it is however, my lord.
Read full.
However, open to the.
Having regard to the fact and
My lord.
ground, I have raised before the court, the regime cognizance of it cannot.
Yes.
Raised before the court below. This is a bit clear. Yes.
It is open to the petitioner to raise all such grounds as are available to him in the law before the court below by filing appropriate application at the appropriate stage.
Yes.
So the appropriate stage is framing of a charge.
Yes.
Whether any application was filed and raised any objection.
There is no scope for the accused to file an
But
application.
you are present there.
Madam,
That is the order sheet shows. You are present there.
my lord.
What he says that after this liberty granted,
Yes.
he was not given that opportunity.
Your Lordship, can
Matter
you
was taken up and immediately it is heard.
how?
Therefore,
My
he
lord,
could
you
not
are
take
present.
Same day.
Same data, that is not the question, that is not the dispute. Dispute is whether you are present or not.
when the order was passed.
Yes,
1910,
1910-2023, page 11, your Lordship.
1910, my lord, your lordship then have your lordship may kind of.
22/12/2021, na? This
My
one.
lord, it was before
Accused,
the Lord
I'm reading, accused person are
minute,
present in court.
1 minute.
It
Understand.
was before the Lord JMFC.
No, this order is passed by the High Court on which date?
My lord, it was in
2012.
2021.
And thereafter, you are reading of this order on
1910-2022. Your Lordship, I'm
why have you
reading.
not moved for such a long time?
Exactly.
Application.
Before commitment, I have no scope.
Is-
When the committal order?
Commitment with your my lord just to 2023 just.
Where is that order? That's what I'm
I will
asking.
show my lord.
Immediately I asked, where is the committal order?
Your lordship may call for the LC appointment.
No, I will not.
Well,
You,
sir,
482 stage, you have to substantiate the case.
My lord, my humble submission.
And not the court will start inquiring about it.
No,
You have to substantiate your case.
Yes, my lord. I am certainly on 1910-2000.
That is what I am saying, sir. That initially I asked the same question. 1910-2023, before that, the proceedings, where is the proceeding?
Yes, I will they'll supply the enter order.
Yes. That is very important.
My
From there,
humble- Yes, my lord, your lordship is that.
December 2022, you got that liberty from the High Court.
Yes.
And this is October 2023.
Yes.
Meanwhile, commitment has already taken place.
Commitment have.
So why have you not moved application? That's what I'm asking.
After commitment, the matter was my lord pending before the session judge and session judge transferred the same to the SJ my lord.
So that time, what transfer in between that?
There is no date, man.
Let us see where.
Yes, I will show.
How can I believe whatever you say
No, I will show.
without seeing the
No,
proceeding?
that is. I will show.
So simply I'm adjourning. You do it. I'll not
My
recommend.
lord, your lordship may direct me to file an adjournment application that will be considered for 7 days.
No. This
Then once my lord.
short circuiting.
Once.
This is the ploy being played.
No, plug, but.
File 482
What-
with incomplete 482 petition. Ask for no. It is incomplete.
Only same my humble submission.
Your second point, how can you substantiate
On
without the
my
proceeding?
lord, it is from the record, my lord.
No,
It was received from the session judge, non 1910.
What happened prior to that? I'm asking.
Prior to the no proceeding before the session.
How will I come to know?
Yes, I will show my next week any date.
You want to press a point, to substantiate that point, you have to supply everything. Then only the court can say.
If the session judge has proceeded something, it is only the discharge or charge. If that happened, says additional session judge has no power to again frame the chargement.
Will you be happy if I'll target the trial?
No, my lord, your lordship, I will call for the, I will supply the copy.
Do it as quick as possible.
My lord.
Take your date according to your convenience.
29, my lord.
20. Okay, then. Okay, next.
27.
February and next.
29.
29?
1 week after, Lordship.
Urgent, urgent, sir.
31.
Yes.
In fact, it is not a resume of argument, it is just for admission. Here, my lord, question is whether a criminal proceeding involving 376 and POCSO Act can be quashed after the marriage between accused and victim.
If you bring early, it will be quashed.
Yes, yes.
Otherwise, we don't know what will happen. So therefore, I wanted to give early date anyway. 30.
10 दिन नहीं
On the 17th.
10 दिन नहीं जाते
I will try.
Take 10 and come.
10 दिन नहीं जा
quash it. Here. 20?
32.
Yes. Urgent. Next.
I will withdraw this matter next week.
You withdraw?
My
Why?
power is not accepted. I am appealing.
withdraw करियो
You want to withdraw this case?
32 withdraw
So next week reply. Nice. Yes.
34.
May Lordship. Here I have challenged the order of cognizance, my lord. There is order dated 23/11/22
This is password matter.
at page annexure 1.
This is password.
Here initially case was registered under section 363, my lord. FIR was registered. And charge sheet was filed, my lord, under section 363, 366, 342, 323, 506 and 34 IPC. The present petition not named in the FIR, my lord. On the allegation one Pintu, my lord. Pintu Biswal. Pintu Biswal is my younger brother.
What is this order 23/11/2020?
The order of taking cognizance.
Cognizance, okay.
I have placed, my lord. Peruse the PP and other connected document available on the.
You want passing of the
Yes, ma'am.
cognizance
Only
order.
for
Where
one
is
person.
where is the charge sheet showing?
But I am not annexed. I have ordered the order of cognizance, my lord.
Without seeing charge sheet, I will pass the cognizance.
I will also take government take instruction, my lord, for the city. It will better, my lord.
Sometimes I feel that I should
Yes,
write
I
a
have also. I have-
judicial
sorry,
order to say
I'm
which
sorry
are
for that.
the necessary document to be filed. No, no, you place it on top. Place it on top.
Yes.
Adjourn it. These are small minimum things. And the registry should not have entertained. In a quashing proceeding, after FIR and charge sheet and cognizance is taken, at least charge sheet has to be filed. Otherwise, how
Yes, ma'am.
how many witnesses are there? I can't be assured about it. And for expediting trial also, I can't pass any order. File it. Give a date. Yes. Next. Give it. Next.
By Monday. Yes. I
Yes.
today I also.
File any day.
Yes, sir. Monday. Yes.
Next. Item.
42.
Obliging.
42, my lord, on behalf of Mr. Pratik Das, my lord, the connected CRLMC has been posted to 7th of February, my lord.
7th February.
Yes, my lord. That is CRLMC number
The
2794.
petition submits that to the connected matter being CRLMC
Posted
number.
to 7th of February, that is CRLMC number 2794 of 2023, my lord.
Is listed on 7th of February. The same may also be listed along with that. 7th February. Next.
43.
43 copy not, sir.
February.
46.
Well, 45.
Please, my lord. I'm paying through virtual mode, my lord.
46. 46, huh?
I'm appearing through virtual mode, my lord.
See, once I adjourn the matter, it should not come before that. Because those who are not coming, and since I adjourned, they will give memo. But don't list. Yes.
My lord, in this case, the order dated 7th of order dated 7th of December may kindly be seen, was passed by this honorable court in this case. The notice was issued on the opposite parties, and on interim measure, the trial of the proceeding has been stayed.
Yes. Have you served? Have you filed
Lord?
requisites and all, service, what service position?
Yes, it has been, the requisition has been filed, the notice has been served to my knowledge. The
Service position. Let's see. Whether it is served or not, just see.
No, postal stamp देना तो किमती notice जीवा.
Your Honor, the notice has been served. I feel my learned friend is no knowledge about that.
Lordship kindly see custody.
Notice has been served through the district court, my lords.
Huh?
Postal stamp देना.
You have not filed the postal stamp, appropriate
My lord,
postal
notice-
stamp, how will it go?
I'm sorry to say, my lord, but most suspect
Sub 302.
it has been filed, my lords. It was filed on the very
Notice, wide order dated 7/12/2023. Problem is, stay has been granted. Stay has been granted. And
Serious case.
what is the stage of trial?
But trial is must be going on because I have.
No, my lords. The stay.
No, there is a stay.
The proceeding stayed, my lord.
Before that, because stay was granted on 7/12/2023.
Charge has not been framed, my lord. Cognizance has been taken, the matter has been.
Wide order dated
It's actually a serious case, and technically they are not filing the postal stamp.
Wrong submission, my lord.
Wide order dated 7/12/2023. The coordinated bench of this court has issued notice to the opposite party number 2, fixing a short returnable date. The court was also pleased to stay the trial court proceeding. It appears from the stamp reporter's report, the stamp report, that the petitioner has filed the requisite with shortage of stamp, postal stamp. So therefore, the notice could not be issued. It is full stop. It is made clear that one opportunity is granted to the petitioner to cure the defect and take necessary steps to serve the opposite party. In the event of failure on his part to serve opposite party number 2, the interim order granted on 7/12/2023 shall be vacated on the next date of hearing.
Interim order till then, my lords.
Huh?
Interim order till then, my lords.
Shall we? That's what I said. If you don't do, it will be vacated. 30th.
Grateful, my lords, grateful.
Yes.
47.
So,
48.
My lord, I have filed this application, my lord, on the ground of, my lord, compromise for quashing of the charge. Here, my lord, that kind of a glance to this, the order, my lord, which I have annexed, that the bail order, page 17, that the present petitioner was arrested and he was in custody. While, my lord, considering the 439 application, page 17, my lord, that this honorable court was pleased to direct an interim order, my lord, that on the submission of the counsel appearing for the informant and on the submission of the counsel appearing for the petitioner, that both are ready for marriage to the victim lady, and that from their wedlock also one male child has also been born. For that reason, my lord, it was advanced before the honorable court, before this honorable court. For that reason, by order dated 16/9/2022,
issue notice to opposite party number 2. Mr. So-and-so, we notice for opposite party number 1. It is submitted by the petitioner that the petitioner has now, petitioner has married with
opposite party number 2.
Very when?
And they have also blessed with a son.
When have you married?
My lord, that documents. Hello, my marriage, my lord.
And baby girl or baby boy?
Baby boy, my marriage certificate and birth certificate of my son.
Tell me the date. You can't throw the papers like this.
No, my lord, no. Sorry, my lord. My marriage date, my lord, that 10/2/2023.
Married on 10/2/2023.
Again.
10/2/2023.
23, after release of the interim bail, my lord, for the purpose.
2023, and a baby boy was born out of the wedlock.
Right.
He submits that when he was in custody, his bail application was dealt with by the coordinated bench of this court, and on his prayer to release him interim bail to marry the victim girl, he was granted interim bail. He was granted bail.
No, interim bail, my lord.
He was granted interim bail.
Thereafter,
Also,
penal.
thereafter, he
Surrendered in time.
he married with the girl victim, that is opposite party number 2, and enlarged on regular bail. So,
Right, order dated 20/12/2022.
enlarged
Page
on
19.
On the basis of their settlement, he wants quashment of the FIR and subsequent proceeding. Issue notice to the opposite party number 2. Yes. So,
My lord, I have filed an IA, my lord, because proceeding is going on.
taking into consideration the above mentioned facts and circumstances, the proceeding pending before the court of so-and-so, application, state till the next date appearing. Next date is February 15/2.
Published.
Yes.
49.
May I please, Lordship?
Yeah, for? You have got the stay order and now. No, not.
Last occasion, kindly, kindly see the order of the 24/4/2023, he was illegally acted while the matter was called. Last time, but the opposite party is a senior man and
When the stay order was passed?
actually 10/3/2023. 10/3/2023. Next to the last time. Check bounce. I have filed a petition on 143A of the NI Act before trial at two charge. That application was allowed by the trial court with a reasonable order. Against that order, I have filed the great charge and we see the conduct of the petition. What is the conduct?
You can't take a interim order and seek. And last time also you have taken a.
1 year.
Last time also you have taken adjournment.
1 year.
1 year you have stalled the proceeding.
And I am also moving as a beggar for the court by the.
What check amount?
Check amount to 5,50,000.
What is the ground of quashing? What is the ground, you tell me?
The kindly see the page 5 para 9 of the petition. 9 that it is what necessary to mention here that the lawyer JMFC.
Let it be on 17th.
Yes, madam.
17th. Yes. I am not saying anything. I am not saying anything. Simply it is, I am not taking it up.
17.
17. Yes, next.
Item 50.
May I please? Last occasion, notice was issued a lawsuit. So noting shows that in the cause list lawsuit, notice valid services made, but nobody appear. Yet the case lawsuit on the ground of compromise.
What is the service position? ये देखो सर्विस हुआ
Tracking report not called.
ट्रैकिंग रिपोर्ट है जो
लिस्ट रे लिखा है what list रे लिखा
कौन लिखा है
Service company. AD return, service
अच्छा आईडी डिटेल्स हाँ यू टेल मी व्हाट इज दिस केस
Yes, also on the ground of compromise, the petitioner seeking the questionment of the criminal.
What is the offense?
Offense of 498, 294, 506, 34 IPC, the 4 of DP Act LRC. The during pending of the civil proceeding of the instances of the husband LRC present petitioners, the matter has been settled amicably, and the page 62 LRC can have a glance on the interference of the London Judge Family Court LRC. Counseling was made in the court LRC, and that has been settled in 5 lakhs rupees as a permanent alimony, and the matter, all the matter will be put out LRC. And accordingly, page 63 on the said date LRC on 1/8/2023, he has a deposited DD of rupees 5 lakhs LRC. That is at page 63. Accordingly, both the wife and husband given evidence affidavit before the Judge Family Court, and thereafter, as per the term and condition, they will withdraw all the proceeding. The wife has also withdrawn the proceeding, DB proceeding. That is also I have annexed the order for DB court, and the family page 60 the order 21/8/23. The wife has already withdrawn the DB proceeding, and the present criminal proceeding is pending before the court below. And meantime, already the CP has already been disposed of on that ground also. Compromise ground.
DB proceeding written, that is altogether different.
Yes.
So far this criminal case is concerned, no grounds have been taken. Whether that ground has been taken in the CP proceeding.
Yes.
Court अच्छी लिखा है जी कोड देखले
Evidence affidavit lordship. Page 66 lordship can have. And the piece of page 67 clause E on top lordship, that the respondent wife has also filed a criminal case against the petitioner husband and his family members, which is pending for the SDGM Sambol during GR case number 4503/19 under section 498 sons of offences, wherein the present petitioner and the family members have been arraigned as accused person. Now the respondent wife declared that in view of the settlement and the resolution of a dispute among them, the respondent wife shall not proceed further and cooperate till disposal of their case number so pending for the SDGM Sambalpur, and file petition before the court making a prayer to dispose of the same being not pressed by respondent wife.
This application was filed by SK Sagari.
This is evidence affidavit of husband.
Husband affidavit ଦେଇଛନ୍ତି.
Yes, thereafter 71. This is the wife.
ସେଇଟା ଦଉନ ନା important
ସେଥିରେ ବି ସେଇ page 73 clause E LRC.
71.
73 LRC. This is the evidence affidavit of wife before the Lawrence Judge Family Court. And it may clause
Farad Begum.
Yes, LRC.
Farad Begum.
Minus.
R.
So,
Parveen.
wife.
Yes.
In clause E, similar statement he has given before the on affidavit.
Which court? Family court.
Family court LRC.
And thereafter, this is you are.
As an instruction LRC that has been allowed LRC, both the CP has been allowed, divorce has been allowed LRC.
13B. Yes,
No,
yes, 13B.
they are the Muslims LRC.
Mutual divorce.
Yes, LRC. On contest, the CP was filed, and during pending of CP, matter has been settled, and money has been given.
What is CP?
Civil proceeding LRC.
Right. Hotel civil proceeding.
Civil proceeding कौन है?
Minus.
CPDP, how can I?
Minus.
Yes.
At that time.
So it will cause any.
वास्तव में किसी problem नहीं, but से notice टा पाइचे आगुड़े chance दिया जाए. Notice टा पाइचे से appear करनी.
पैसा नहीं गला.
से पैसा नेला कि ननेला सेटा सिना और डिफॉल्ट ला माने खेली थे बेटा साइर कौन एमती किसी माने नहीं. बर्तन जा होची family court रे. माने nobody can believe. to short extent.
No, that is recorded in the order it seems.
Recorded ଏଠି ଅଛି page 63 ରେ ସେ
ନାଇଁ,
ପଇସା ନେଲା
ଆରେ,
DD ହେଲା
ସେଟା ଠିକ ଯେ ସେଇଟା
ସେଇଠି
ହଉଛି କିନ୍ତୁ ତାକୁ ବାହାରେ ମନା କରୁଛନ୍ତି ନା ଏଠି କହିଦଉଛି ତୁ admit କର ଏଟା ତ ଆମେ
No,
ଲେଖୁଛେ ନା
you have given in the form
at
of
least one chance will
order
be
ରେ
given.
ଲେଖିଛନ୍ତି family court order ରେ ଲେଖିଛନ୍ତି order sheet have given page 63
outside the court. If a sum of 63 na.
is letter ସେ piece 63 ର third para ହେଲା ସେ letter on the ଯୋଉ ଦିନ conciliation ହେଲା 5 lakhs decide ହେଲା ସେଇ ଦିନ letter
Accordingly, permanent alimony to the tune of 5 lakhs is finalized to be paid by the behavior.
ରିସିଭ୍ କରିଛି ବୋଲି କୋଉଠି ଲେଖା ସେଟା ଟିକେ
ରିସିଭ୍ କରିନି
Put up
ସେଟା DD ଟା ଫାଇଲ ହେଲା କୋର୍ଟ ରେ
for evidence and filing of DD and
ହଁ, ମୁଁ ଆଉ
towards the permanent alimony.
କଥା ରହିଲା ଯେ ହାଇକୋର୍ଟରେ ପାସ୍ ହେଲା ପରେ ହବ ଯେହେତୁ ଏଠି ଡିଲେ ହେଲା ଷ୍ଟେ ହେଇଗଲା ତାପରେ CP ଟା already allow ହେଇଯାଇଛି
ନାଇଁ, ଏଇଟା ଆଲ୍ଲାହ ହେଇଛି ଠିକ କିନ୍ତୁ ସେଟା କୋଉଠି ରିସିଭ୍ କରିଛି ବୋଲି ସେଇଟା ମୁଁ ଝିଅ ପିଲାଟା ନା କୋଉଠି ରିସିଭ୍ କରିଥାଉ ଯଦି ରିସିଭ୍ କରିଥାଉ ଠିକ ଅଛି ରିସିଭ୍ କରିଛି ବୋଲି କିଛି ନାହିଁ ବାପାରେ ମୋର ବି ଭଉଣୀ ଅଛି ତୋର ବି ଭଉଣୀ ଅଛି ଏଠି କେବଳ ୱିଲ୍ ଲେଖା ହେଇଛି ଯଦି ରିସିଭ୍ କରିଛି ବୋଲି ଥାନ୍ତା ମୋର କିଛି କହିବାର ମୁଁ ମନା କରୁନି
Maybe you have submitted the DD. Thereafter, the evidence is closed.
yes sir
Thereafter, what happened? See, DD is dated. DD is dated. I'll tell you. Now dated 27/7/2023.
my lord
DD.
my lord
You have deposited that in the court.
yes sir
And evidence is closed.
yes sir
Thereafter, whether it is encashed or not.
yes sir
How? Where from?
argument kai court
Your AS will
final
not
order
make
kai
everything yes. Show me something. I am searching. You have to tell me.
yes that is not in on record alert.
So
Final
then how
order
will
ta
you know
diyantu.
that money is gone or not?
Yes,
It
sir.
might be lying there.
No
And
the-
it has expired. It has expired now.
my lord as per condition the after passing of this proceeding they have to get but
See, 27/7/2023 the DD.
Yes, sir, Lord.
It has to be renewed.
yes
Once I'll pass, you will not take it and renew, then that lady is left in high and dry.
submission Lordship, keep it to 1 week after. I will produce the final order passed in the civil proceeding.
Show me that she has taken the money.
Yes, sir. Lord.
See, the problem is.
Also, my Lord senior may be asked for take instruction regarding whether he has through police or lordship, whether he has received the same or settlement. What
See, if see two situation. If she has already taken the money, she will not take interest, whether it is quashed or not.
ଆପଣ ସେଟା ଦେଇଦେବେ ଏଠି
That may
କ୍ୱାସ୍
be a
ହେଇଯିବ, ଆପଣ
reason.
ଦେଇ ଦିଅନ୍ତୁ ନା
I will produce.
ଆପଣ ଦେଇ ଦିଅନ୍ତୁ କ୍ୱାସ୍ ହେଇଯିବ ତ କଣ ଅଛି
Give me that proof, I'll pass.
exactly
Yes, sir. Well,
Only that extent we have to
7
protect.
days after lordship may keep, I will produce
When?
Huh?
29th. 29th.
Yes, sir.
Chetti khali de dile.
Yes, yes, sir.
We have to protect them.
Okay.
Thank you. Order sheet